Have his phone at the scene where this body is.
I'm not disputing that.
I have this woman along with another woman, as I'm done, that goes into his house. Her phone, deceased phone, is pinged to that his location. And then also understand nothing else after. So there is certainly a whole lot that can be made up in there, or soon to be, but I got somebody that said the last place I had a person is his house. That's what I got.
We have to legally
Right, I'm around PA 3665. I'm Mr. Bashar. To our right, just state your name for the record, sir.
Thank you. This is date time set for the decision on the bond motion. Was there any additional information or argument?
Yes. There is some additional information. The court was kind enough to adjourn it that we could get a copy of the discovery, and we did get a copy of the discovery. If the court recalls, at the last hearing, I said, we don't know what the cause of death is. It could be, yes, it could be homicide, it could be a drug overdose, if the court recalls.
I recall.
Two things that I would like to update the court on. First, I was puzzled by the medical examiner's statement that Ms. Blanche was kind of to forward to me, where she said it's consistent with homicide that the manner and cause of death may never be known. Those two statements, to me, called the medical examiner and spoke, and she said, I'm not going to talk to you about this because I don't have anything final. And I said, saw the email to Ms. Blanche, and she says, well, that was Friday. Judge,
PA 3665. To our right, just state your name. the record, sir.
private
Thank you.
not to be shared with defense counsel. But Ms. Blanche understood ethically that she was required to do it. I commend her for that. So I don't have any more information, but she certainly just couldn't explain how those two statements be reckoned. But more importantly, Your Honor, I got the discovery. In the discovery, I'd like to read to you a portion of it. It's not very long. What was necessary in this case is that Mr. Haraj had 2 escorts at his house on the evening of the 22nd, going into the early morning hours of the 23rd. Escorts was a woman named Paris, who lives in New Jersey, and I'd like to read to you what it says. Paris said they returned to Habibi's rest. Paris said that girl Susan, in that case, Susan, Paris said there was another girl, same hotel in Novi. Bobby wanted her to call Susan over. Habibi to pick Susan up and to bring her to his house. Paris said when Susan arrived, the 3 began drinking and said they went into another house and they started using cocaine. Paris said she does not use drugs and decided to leave. At least from this that was present, is that Suzanne, the deceased, was doing cocaine.
There is some additional information.
And could have overdosed, we had a heart
The court was kind enough to adjourn it that we could get a copy of the discovery. We did get a copy of the discovery. If the court recalls, at the last hearing,
I don't know.
we don't know what the cause of death is. It could be, yes, it could be homicide.
Depending on
drug
who supplied the cocaine,
if the court
but
recalls.
certainly it being at the location,
2 things that
if it's that drug overdose
I would like
that
to
then
update
results in a
court.
death, you got a
First-
whole other problem.
puzzled.
and I recognize that. But
The
evidence in this case, the discovery, there is no evidence, and I mean, burden of proof is on the people or the prosecutor. There is
forward
no evidence that those drugs were supplied. Nothing. There was a weapon, a backpack belonged to Suzanne Clear, although the wife did not test positive for cocaine.
Those 2
So
statements to
But
me
the point that I'm trying to make, the burden of
called
proof
the medical examiner and
the
spoke
government at every stage of the, although the burden of proof is lower at a
But counsel, I don't leave behind my just comment. I mean, I'm not sure
Blanche
everything.
ethically that she was
Maybe it's
required to
helpful
do it.
because
I
so I don't know cocaine. I would have, that's not what happened.
I mean, so a man isn't even charged on
This whole thing is
You're
you're assuming drug over no
not
test.
assuming. What I am, the court was extremely, that may have been omitted that homicide, and all that, but there's no.
No. That becomes, I was overly counsel, phone, the scene,
Disputing that.
I have,
discovery.
along as I'm to understand,
In the
goes
discovery, I'd like to
her
read
phone,
a
ping
portion of it. It's not
location.
very long.
And then also
What was
after
necessary
that,
in this case is
there were a
that
whole lot
Mr.
made up in
Haraj
there
had
to be,
2 escorts
but
at
I
his
got
house on
the lad that is his
the evening
house.
of the 22nd, going
But I
into the
got-
early morning hours of
I
the
need that, Your
23rd.
Honor. They have this phone, I
Escorts
did
was a
bond. I
woman
asked for
named
100% bond.
who lives in New
Has not
Jersey.
recognized
And
circumstances he wanted to believe, although he's presumed that somehow he
And
homicide.
I'd like to read
It
to
is a
you
homicide. Is
what it
that
says.
all we know is
Paris
woman
said they
in a
returned to
field
Habibi's
in that
rest-
location, but he has
Paris
the
said
murder,
that Susan,
Judge,
and
and
that's okay,
maybe I'm
Susan,
clear,
she-
saying that it should some
Paris said there
kind
was
of,
another girl,
although
hotel
in
Novi.
Michigan,
Bobby wanted wanted
million
her to call
surety
Susan
bond, a
over.
bail
The
bond,
BB took
200,000
Susan out and to
fundable.
bring her
He
to
said
the
a 2 million
house.
is
Kara
appropriate.
said when Susan
All due
arrived,
respect,
the three began
at least
drinking and said
there's a
they went
case
into another house and they
Liz
started using cocaine.
And in there,
Kara said she does not use drugs and decided to leave, at least from this that was present, is that
this is a case where the charge is murder
deceased
and allows him to be released on bond. Court of Appeals, the statute says that bond shall be denied with the proof is evident or the presumption great. It then went to the Michigan Supreme Court, and the Michigan Supreme Court remanded it back, saying that's inconsistent. Is that inconsistent with the court rule and with the Michigan Constitution that says maybe, ultimately the Court of Appeals ruled that a defendant can be admitted to bond even where the proof is evident or the presumption great. And that's a case where he was actually charged with murder. The court does not say what the bond was in this case. But in our case, the court said bond ought to be reasonable. So what I'm saying, Your Honor, is I'm not asking this court to release him on a personal bond. It's obvious to me, and I've been doing this long enough to read the tea leaves that this court is not going to grant a bond that I've requested of $100,000, 10%, but a $2 million cash or surety bond where the defendant has not been charged with a homicide. It's not even clear that it was a homicide. I just think that that bond is unreasonable. So if the court made it a 10% bond, at least they could post it and maybe get some of it back at some point. But I also want one other thing. If the court will recall, if you look at all of the factors that are set forth in 6.106, one of them is a third-party custodian. I introduced the court to a former Detroit police officer who has known Mr. Jar since they were in high school together. He said he would act as a third-party custodian. He's a retired police officer, but there's nothing in Mr. Hajar's background that would indicate, outside of this offense, that he has ever had any tendency towards violence. I just think that, while maybe a substantial bond, if the court feels it's appropriate, so be it. But $2 million cash or surety, I think is excessive in violation of the Constitution. I've said my piece, Your Honor.
You would agree that reasonableness would also have to be balanced against one's means.
Correct. And if he had $200,000 in the out by now, Judge.
The evening of the 22nd, going into early morning hours.
So, do you want me to go through and just pull all of his financial records and anything that he's attached to in order to make a proper determination of reasonableness? I mean, that's what's going to have to happen. I mean, if I take your argument, that's what has to happen.
If the court was prepared, if the court wants its financial information, I'll supply it. But again, and we talked about this, Your Honor, that I said that really, whether he pays a bail bondsman $200,000.
Because I think, if I take the financial things, my understanding is he's tied to 11 different businesses.
It works for Cromwell still, that's what you're doing.
And that he has an interest in 12 other companies, or 11 other companies.
I don't think that's accurate, Judge. He has his own, he has a business on the side where he does IT work. And then the Michigan Supreme Court, and the Michigan Supreme Court remanded it back, saying that's inconsistent. Is that inconsistent with the court rule and with the Michigan Constitution that says maybe, ultimately the Court of Appeals rule, that a defendant can be admitted to bond, even where the proof is. There's one other business, and at this time it's not even showing a profit. And if the court wants to put him under oath, subject to the penalties of perjury, so be it. The court said bond ought to be reasonable.
You're really making this a whole lot more complicated, I think, than me. I mean, I'm willing to go there if that's what you want me to do.
Well, no, what I would really like, Your Honor, is if you could make it a 10% fine.
I know. That's what you would like.
That's what I would
And
like.
the people object.
That's right.
that's where I'm trying to balance where I land on.
Correct.
And I can only get there by what I see in the case, what risk he could pose to me, or what risk he could pose to the community.
But he would be on a GPS tether, and if the court requires him not to live in his house, to live with Mr. Garza, he's prepared to do that. I've spoken to Mr. Garza, and he said he would put him up. But again, I just keep repeating myself, Your Honor, but the point that I'm trying to make is there is no evidence at this stage that there was a homicide, that the cause and manner of death. So what you're looking at is a guideline range of either 0 to 17 or 10 to 24. It's tops at this stage. If he's charged with murder down the road, then of course the court would have the option to prove his evidence or the presumption rate to deny bond and remand. But at this stage, for these charges, even given what you characterize as suspicious circumstances, I think a $2 million.
Counsel, you need to stop with what I'm characterizing. I am just laying out what I know. That's all I'm doing. I'm not giving weight to anything at all. I'm just laying out what I know.
Right, but I think the court is concerned about the safety of the community because of the circumstances.
Anytime there's a dead body and somebody's around a dead body, yeah, darn it, I'm a little bit concerned.
Right, and understandably so. And that's why I don't expect the court to release him on some nominal bond. But $2 million, 10% is not a nominal bond. It's a substantial amount of money. And the court wanted him to, in addition to that $200,000, 10% bond, to host a house where he lives. We're prepared to do that. And that gives some surety in addition. But I think a $200,000 cash security bond, the episode bail bond, this huge premium that will never be returned when he hasn't been convicted of a crime, he hasn't even been charged with a homicide, and he's only facing at this stage a charge that carries a maximum of 24 months under the guidelines. Now, I understand the guidelines are not mandatory, you know that, but, Your Honor, we live in a country where a person's presumed to be innocent, and there's no evidence in this record at this stage that this was a homicide, other than a statement that seems to be consistent with a homicide, but I don't know whether we can ever determine the cause and manner of death. Judge, I've been beating a dead horse, I said the other day, but again, if the court does not feel that something less than a $200,000, 10% bond is appropriate, so be it, but I think that's a reasonable, fair bond under the Constitution.
What I would really like, Your Honor, is if you could make it a 10%.
I know.
Just I just want to make the record correct on the fact that the medical examiner didn't email me. I actually received the email through my officer, so she wasn't emailing me and saying, don't share this because this wasn't what happened. She shared it with my sergeant and he sent it to me. So I just want to make the record correct on that. And he's right, this is not a homicide. That's why I'm not asking the court to deny the bond. I'm asking you to set a bond. We had asked for $10 million to begin with. And under reasonableness, he's saying they can actually post this bond. They just don't like the fact they're not going to get the money back. Which if you're making that statement, then how are you saying it's unreasonable? When you actually can pay for it, you just don't like the fact that you're not going to get the money back. I was quiet during your argument, sir, and that's what you said. Judge, when it comes to cocaine, he's relying on, he's telling the court that an independent witness that suggested that the victim had ingested cocaine that night. I don't want to try this case right now on the record. However, the defendant said there was no cocaine at the area. He doesn't partake in those drugs, and there was none there that night. So there's conflicting statements around whether or not cocaine was actually at the place. So to just blatantly say that we have a witness saying that, well, the defendant said there was no cocaine there that night. And this backpack that he says belonged to the victim, she walked in with suitcases that night. The police asked the defendant for the suitcases she walked in with, and he doesn't know where they are. So I'm just concerned with the kind of portrayed on the record.
Hold on. I want to make sure I understand this. Who is saying that she walked into suitcase?
Sorry, this video that's showing her walking in the suitcase. How came to his house and then the suitcase was gone. Judge, I don't believe the found is unreasonable circumstances. I'm not asking you to give $2 million based on the fact that, this is a homicide right now. I'm asking based on the fact of defendant's misrepresentations to the police that night, the fact that we have a missing woman last seen going into his house, never coming out, and then his car going up to the township, and she's found dead in the place that his car was at. That alone, those circumstances, I believe that he presented extreme danger to the public, and I believe based on that, you can rule $2 million for his bond, and I don't believe it's unreasonable. He's already said that the post is $200,000 for 10% to a surety bond, so I don't know how you can make that argument, Judge.
I can tell you exactly how I can make that argument, because a bail bond requires collateral for the rest of the money. So they'd have to post collateral of $2 million. They don't have that. That's the problem. If it was just the $200,000,
It seems to be contradictory.
they not, they could raise it, although I think it's punishment. They have to do a non-refundable $200,000, but the bail bonds require surety such as a house. And that's $2 million because the bail bonds need to protect themselves. No one's ever argued that he was a risk of life. And again, this is a man in his 50s and has never been in trouble other than a 12-year-old drunk driving.
What about the suitcase? What about his statement?
Even a statement about the cocaine?
No, about the suitcase. I mean, that's part of the problem. Part of the problem here is that there's going to be all of these things coming out that are going to cut one way in or another. And so I was, at least for the purposes of this decision, satisfied to say there are certain misrepresentations to people that was contained in the people's vote. But now when I get down into the specifics of what those misrepresentations may be, that raises more concern.
When it comes to cocaine,
I mean, because the witness you're talking about went through a lot of things about it potentially being something involving drugs. Then we find out, and you quote his statement about, only to find out their client's denying that there was ever any drugs. Then it just gets worse. I mean, at least in terms of my analysis of what risk he poses, because now I have that woman walking in on video with suitcases. She leaves there, a suitcase is not to be found. They ask for suitcases, he doesn't know where they are.
There was one suitcase, it's not plural, but yes, the video
And
shows
where's
the
the suitcase?
I have not spoken about
No, but that's what I'm getting at. You want me to make an assessment regarding your client, the risk he poses. The more this stuff comes up, and when I ask the hard question, nobody wants to give me the answer.
I do my best. It's not unusual, at least in my experience, that people make false exculpatory statements.
I get it, but they don't hide evidence. I mean, that's the problem that I have in this. Now, I come back today, and there's this other added thing now. And that I think I can take into account in terms of the bond.
I'm not saying that you can't take it into account. That's never been my argument, that you can't take those things into account. My argument is, Judge,
Counsel, tell me what I now do with now an indication that there is potential evidence that is missing, and a statement, I think, or at least an indication to people that your client is misleading authorities as to the location of that. What do I do with that?
I'd have to go back and look at the discovery because I don't want to misrepresent what the discovery. I don't recall exactly what he was questioned about the suitcase, but I know it came up in the interview. I just don't have it in front of me. But let's assume that he misled, just for argument's sake, he misled the police about that. I go back to my original point, that the bond in this case, if all of that is true, then still, I think a $2 million cash or surety bond is excessive and unreasonable. And all I'm asking for, Your Honor,
So it might need to be more. If somebody is, if I come to the assessment that not only is he misleading authorities because he has the right not to say anything. That's one thing. But now when the statements are being made and he's misleading authorities, and that it may look like certain evidence is also being secreted away someplace, that changes the whole thing.
I don't know. The evidence seems to be somewhat clear that they can place him in the house and place his car where the body was found. How his suitcase would add or subtract from the strength of the case, I don't see it. But I don't have any answer.
It depends on what things happen. Because now I have that.
Again, Your Honor.
And then it would also depend, and it may not add or subtract anything to the case. But then you have to ask the question, if I have an individual that then is not, well, the defendants necessarily have to cooperate with authorities, but that is then not turning over evidence.
There was
That puts you into a whole other place. And you know that.
They did a search warrant on the house.
No, but counsel, they know that something exists. They ask your client. They have proof that something went into that house. That's correct. They ask your client. Your client says that it's not there. Whatever he said. You know that puts any argument that's being made, and then I think I can take into from any court's perspective in terms of reasonableness of the bond, that puts it in a whole different. That's what I'm saying. It's getting worse. Indication that there is again evidence that is missing, and
Let me just keep repeating myself. I'm not asking for a nominal bond. $200,000 is a lot of money. A lot of money for someone that's not charged with a homicide and is presumed innocent under our Constitution. Again, I'm not even, $1 million would be a sizable bond for someone with as it sits today, where there's no evidence that it was a homicide, that they haven't found the cause of death to be a homicide or the manner of death to be a homicide, and it would seem to me that
but you have to factor into that. I also have somebody that it is also alleged lying to, who also is having evidence that they're not turning over to the police and or have secreted it somewhere and or destroyed. It doesn't go one way.
and I'm not saying it does go one way, but all I'm saying here is $200,000 is a substantial bond. It's 10%. That's all I'm saying. I'm not asking the court to release it on a personal bond. I'm not, although with my original request to do $100,000 $100,000 10% bond, but he's not charged with murder at this point. And they haven't even shown that it's a homicide at this point. And it may be quite some time before that happens. And he sits in jail on a case that has, at worst, 10 to 24-month guidelines. That's my argument, Judge, and I don't mean to keep repeating myself. I'm just asking that the court reduce it to this point.
They can place him, they're in the house,
Anything else?
place his car with the body.
Court's gonna stay in recess.
This case would gather subtract from the strength of the case. I don't see it. I mean,
I don't
have
Counsel is present. The court has reviewed the Court of Appeals case, read over the Court of Appeals cases provided by the Let me first say, as I said at the end of the last hearing, I do not believe that the bond is set by the magistrate, at least based upon the information that the court had at the time, this court had at the time, that this court could constitute, say that was an abuse of discretion. What is notable, the defense is argued, and all of it certainly being legally correct, but then again, taking those arguments and applying them to particular factual circumstances, at least as the court would know them at this time, maybe where there is some difference. Notable, the defense's statement that the $200,000 that might be required to pay a bond, that could be accomplished, but that then there is that the real crux of the issue is that should everything go forth through trial and everything, where there would then be a release of that surety that the defendant does not get that back, or the monetary funds back. That is correct, but they're also not having to put up the entirety of the $2 million. But what's notable in that is $200,000 could be indeed posted. The more the facts are laid out before this court, the more the court has not just questions, but certainly has concern about safety to the public. I don't doubt that there are individuals that are basically a full courtroom the last hearing. There would be individuals who would vouch for the defendant could be released to. That isn't the court's concern. What is of concern to the court is that as this is ongoing, the risk, the danger, as it is uncovered as to maybe what occurred in this case, would lead the court maybe to a different conclusion as to the defendant's danger to the community, the threat that he may pose. By way of example, certain facts today, some of them laid out in generality, not in specifics, were not known to the court just last week.
that this court could have.
And they do give this court great discretion. And I don't think it unreasonable for this court to take into account what may be statements made for the purpose of misleading an investigation and or the concealment or the destruction of potential evidence in the case. One of the reasons why I wanted counsel were going through a few things last week that the defense at least be presented with to have been discovered in case those arguments were made. That having been said, the court is going to rule in this case that the bond is set by the magistrate. As I've indicated, I don't believe it is unreasonable. I do not believe, under the circumstances, I do not believe that it is unreasonable. I do not believe that it was an abuse of discretion in terms of the magistrate setting the bond. To be quite frank with you, given what I learned today, it might lead this court to think that a higher might be required. But I'm not going to do that either. I'm going to leave the bond where it is at $2 million in cash or surety so that it can be posted. I will do this, however. Should the defendant not post that bond, I would give the defense an opportunity to produce to the court certain financials, which I think the court, certainly under court rule and otherwise, can take into account in terms of his ability not necessarily to pay the $200,000 to the bondsman, because it's already been acknowledged by defense that they can do that. The question is the collateral that would frame up $2 million. And the court would take a look at that and then reevaluate if bond posted. The court would then reevaluate and take a look at the bond. I would also say, however, because of at least what the court knows or thinks it knows at this point in time, that as a additional condition of the defendant's bond, the magistrate did order the GPS tether. I would order that if the defendant introduces a GPS tether is to be placed on the defendant prior to release. Indicated also he would have to surrender any passport or any other documentation which would permit him to travel outside of the United States. Additionally, as part of this court's order, given what I've seen, that should there be enough evidence at some point, and this will be a condition of his bond, that if there be enough evidence, people would file and charge the defendant with open murder, first or second degree, or any other type of homicide type of an offense, that the defendant bond as set would be canceled, and he would then have to surrender himself immediately to the Washington Secretary if those charges were to come about. And that would, as indicated, be a condition of his bond in this case. That is the ruling of this court. Is there any questions regarding the court's ruling?
I do have a question, but two questions. One is a comment, not a question.
I had proposed to the court that in addition to the court would impose a 10% bond, that in addition we would post the house, which would be similar to what a bail bond required. I'm not sure how much equity there is in the house, but the court would consider that. And I think there's a relative that would also post a house in addition to his own. So I would ask that the court consider that. The second question I have, the next comment I have, the passport is already in the possession of law enforcement. It was at a safe that was taken at the time, and that is in the discovery that they have possession of his passport. The question I have, if somehow at some point he does get released, can he work? I know he has to have a GPS tether, but like his employers, I gave a letter to the court last week, said they would take him back.
Because would he leave the state of Michigan?
No, he would not leave the state of Michigan.
Originally, a home confinement was ordered, so I don't know if that was not unreasonable to keep by the court, but that was originally the home confinement was ordered on his spot.
Without much else, I don't know that I can order a home confinement. Just order GPS tether location tracking.
Would the court consider if he could post two residences that equal, let's say,
I think that's very
okay. I'm gonna shut up, Judge.
The bond is set. Cannot be posted. I'm giving the defense an opportunity to provide to the court financials that would lead the court in the direction or to restructure this bond.
Thank you.
So with those conditions, defendant's motion on the reduction or change in bond, I've given the opportunity for you to do other things and provide that to the court. I will look at it. I will diligently look at it. And if there's something that can be fashioned, I will do so.
I appreciate it. May I have a word with the client and my co-counsel regarding the next probable cause conference?
At some point, this will be a condition of his bond.
The people will prepare their order for the court signature. Yes.
File and charge open first or second or any other type of homicide type of an offense that the defendant bond as set would be canceled. He would then have to surrender himself immediately to the Washington authorities if those charges were to come up. And that would, as indicated, be a condition of his bond. In this case, that is the rule of this court. Is there any questions regarding the question?
I do not. That microphone, you might want to hit that so that it's not picking up. They're very sensitive, so it needs to be green. It should be green. Yes, and after 25 years sitting here, my longest one ever.
I'm not sure how much equity there is in the house, but the court will consider that. And I think there's a relative that would also post a house in addition to his own. So I would ask that the court consider that.
Your Honor, we would ask the probable cause conference to be put over 1 week or so that we can see whether there's a wherewithal to post the bond under the current conditions or whether we need to present financial information. So that would be, pardon?
That would be August 1st.
Can I just check my calendar, Judge?
To the court last week, said they would take him back.
That's not even what he needs to state.
That looks good. Do you want to do it at 3 o'clock again?
No, here's what would happen. My PCCs are set in the morning. If you were to file something or wanted something heard, it gets switched to the 3 o'clock.
Okay.
So, I set everything at 9. You will get a invite from the court, which puts you into one of the hour blocks throughout the day, so that you're not here all day waiting.
Okay, and then
You're set in the 9 o'clock block,
I'm gonna shut up.
9 o'clock block because the in custody block, which currently he would be set in, is a 3-hour block.
May I touch the bench with the prosecutor for a moment?
Morning, Your Honor. Ashley Lonnie Phelps, Court of Appeals.
Good morning, ma'am. Please, I'm before to reach out on behalf of Mr. Clinton, motion seeks for rights.
In your name, sir? Thank you.
Your Honor, we are set this morning for preliminary examination. It's my understanding after talking with Mr. Johnson that we are proceeding to a preliminary examination. People anticipate calling 4 witnesses, and I have a copy of the revised post-mortem examination report that I am admitting pursuant to statute with no objection from defense counsel, if I may approach with Exhibit 1.
The people will prepare their report. Is that all correct, Mr. Judge?
Yes, Your Honor.
Exhibit 1 is admitted.
And Your Honor, I have 4 witnesses: Ronald Fleming, who is not the defendant, born a different year, Detective Thomas Robb, Detective Aaron Swyring, and Detective Heather Morrison, who's my officer in charge.
That's fine. All right, let me call your first witness.
The court admitted Exhibit 1, I apologize.
I did.
Thank you very much.
Hours ago.
Yes, people would call Ronald Fleming for 1971.
I do have that microphone. You might want to hit that so that it's not picking up the very sensitive. So please come forward to be sworn. It should be green. Yes, after 25 years sitting
Right
in
hand,
my
keep sounding swear in front of the testimony about here. Who holds you the judgment? So you got it. Whatever. States go to first last name.
Good morning, sir.
We would ask the probable cause.
How do you know Ronald Savoy Fleming? He's your son? Do you see the person you know to be Ronald Savoy Fleming in the courtroom today? Could you tell me where he's sitting and what he's wearing, please?
Current conditions, or whether we need to present financial information. So that would be.
Your Honor, may the record reflect that this witness has identified the defendant?
That objection, record shows those.
Did you know a person named Theodore Fleming? Who was that? Your mother was Theodore Fleming? Do you know what township your mother lived in 2024? Did you have occasion to go to her house on May 17th, 2024? Why did you go to her house on that date?
File something or wanted something heard, it gets switched to the street.
Mother, sisters, they would next to each other every morning. Go to slide to see if they're still around.
Well, how old was your mother at that point in 2024?
Set in the 9 o'clock block, 9 o'clock block.
73.
Currently.
And after you had heard from your aunts that they hadn't heard from your mother, what did you decide to do?
Come on,
Morning, Your Honor. Ashley Lonnie Phelps, Court of Appeals.
good morning, please, I'm before to reach out on behalf of motion seeks for rights.
In your name, sir?
And where do you live at? What city?
It's my understanding after talking
And
to
where is
Mr.
that?
Johnson that we are proceeding to a preliminary examination. People anticipate calling 4 witnesses, and I have a copy.
A little bit of a drive to come up to Ypsilanti Township.
Revised post-mortem examination report that I am admitting pursuant to statute.
Did you arrive at the house
Defense counsel,
on
if I
May
may
the
approach
17th,
with Exhibit 1.
2024? How'd you get there? Where did you park when you got there?
Is that all correct, Mr. Judge?
What did you notice about the house when you drove up to it?
One is admitted.
Knocked out. All the windows, the sheets on the windows were shattered.
Why did that pop out to you?
Detective Aaron Swyring and Detective Evan Morrison from the officer in charge.
Fully cut all the sheets.
They call your first one.
Exhibit 1, I apologize.
Was that something your mother would routinely do?
People would call Ron Fleming.
Would always have them open? Did you notice anything else about the house?
Actually, no. When I got out, knocked on the door, and it said, "Go screen door on." From the inside, it was snowing. But with the shades closed, and then it's something this is way out of here.
Did you notice any sounds coming from the house? Did you go up to the doors or windows and try to knock on them or see what was going on?
Front door, as well as
Good morning, sir.
side realized
Ronald Savoy
screen
Fleming.
door locks or
Is your
no
son?
access.
Do you see the person you know to be Ronald
So
Savoy
what
Fleming
that's
in
in
the
front
front
of
today?
them.
Could you tell me where he's sitting and what he's wearing, please?
Just like a response from the dog.
What kind of dog was it?
Your Honor, may the record reflect that this witness has identified the
Bullmastiff.
defendant?
Was it a big dog? Did you hear any response from the dog?
Phaedra Fleming? Who was that? Your mother was Phaedra Fleming?
Rushed against the,
Do you know what township your mother lived in 2024?
I just kept having fun with the window.
Did you have occasion to go to her house on May 17,
What was going on? But
2024?
I see.
Why did you go to her house on that
First
day?
thing I noticed was called into the dog, watermelon. Full. That just told someone was in the house, not answering. Judge speculation. Was there.
When you saw that the dog, when you heard the dog, you said you noticed the water bucket was full?
73. And
Did
after
you
had heard from your
contact
aunts
the
that you
police?
had heard from your mother, what did you decide to do?
I called. Right. Walk around. I was just really checking.
And where do you live at? What city?
As soon as I saw that,
And where is that?
started on order.
People anticipate calling 4
The
witnesses, and I have a little bit of a drive to come up to Ypsilanti Township.
That's all right.
What was your aunt's name?
Did you arrive at the house on May 17th?
Did she have a key to your mother's home? Did she give that to the police officers?
Where did you park when you got there? What
Do
did
you remember the
notice about
address
house when
where
you
your mother
drove up
lived? That's in Ypsilanti Township, Washtenaw County. Now, eventually the police came to the home, right?
Why did that pop out to you?
Did your son ever exit that home? Did he exit the home after the police got there?
Was that something your mother
When did he
would
come out of the
routinely
home?
Would always have them open.
Saw the dog,
Did you
so he
notice
called
anything else about the house?
Washtenaw County. He makes hey, I can't show you. The dog, entered. They proceeded to the inside, entered the house, breaking it. That is it, breaking the box, screen door. He's not going to open up, this is what we initially, the dog entered.
Did you notice any sounds coming from the house?
Police officer.
Did you go
And you
to
had
the
asked the
doors or
police
windows and
officer
try
who
to
came to
knock on
help
them or
you
see what was
with
going
finding
on?
your mom, right? You had asked that deputy that came to the house to help you? You were worried about your mother?
Good morning, sir.
After the dog was secured, did that deputy go inside the home? At some point after he went in the home, did the deputy and your son come outside?
Can you tell me where he's sitting and what he's wearing, please? What kind of dog was it?
Did he ask you to step outside?
Was it a bull mastiff? Was it a big dog?
At some point, did you see your son?
Did you hear any response from the dog?
Was there anything about his behavior that concerned you?
Do you know what township your mother lived in 2001? Did you have occasion to go to her house on May 17, 2020?
What did you notice?
Why did you go to her house on May 17?
Reactions. Judge Foundation.
When you saw that the dog, when you heard the dog, you said you noticed the
You want
dog
to ask
was
questions, I would allow the answer, but
Thank you. You've known your son his whole life, correct, sir? You're familiar with him? You're familiar with how he portrays his emotions on his face? And in this situation, had you seen emotions like shock before on his face?
More so, if I as than sometimes just really take.
And where do you live at? What city?
Somebody has seen that.
And where is that? People anticipate calling forward witnesses.
I don't think he anticipated.
A little bit of a drawing to come up tapes learning countries.
Now,
so the record's there, I'm going to overrule the objection to that foundation. I'm going to allow the
Did she
answer.
have a
Thank you
key
very much,
to your
Your Honor.
mother's home?
At some point,
Did she give that to the police officers?
while
Where did
you,
park when got
your
there?
Aunt Tony, the defendant,
Do you
and the
remember the
deputies
address
were
where your mother
outside
lived?
discussing where your mother might be,
That's in Ypsilanti
did you
Township?
speak to the deputy by
Washington
yourself?
County? Now, eventually the police came to the home, right?
No, initially, no, we were all thinking,
Did your son ever exit that home?
these
Did he
officers
exit the home
passed
after the police got there? Was that something, when did he come out of the room? Always have him out there. Did you notice anything else about him?
Every small. Initially, we thought we were going to kind of Rex and she'd also swim on. She saw me to the house, like, whatever told me to check and see if there's any ambulance reporting, so that she picked up anything in the hospital.
Did you notice any calls coming from the house?
Hospital.
And you had asked the police officer who came to help with finding your mom, right? You had asked that deputy that came to
Actually,
the
it
house.
walked off.
Worried about your mom. After the dog was secured, did that deputy go inside the home?
Well,
I'm not offering it for the truth of the matter asserted, Your Honor. I'm offering it to guide the next steps in what this witness did.
I'll overrule the objection. Take it for that purpose.
Thank you, Your Honor. At some point, did the deputy go to his car that was parked out front?
Did he ask you to step outside? Was it a big dog?
At some point, did you see your son?
Did you hear any response from the dog?
Sure. Skipping ahead a little bit, did you and the deputy have a conversation in the front yard? What, if anything, did you express to him at that time that concerned you?
What did you notice?
Yeah, those were like, initially we were asking questions, this officer asked questions. Steve,
That the dog, when you heard the dog,
as long as I heard,
you said you noticed the
that
dog.
was the question that would allow the answer.
Thank you.
And then there was
You've known
some
your son
false
his whole life,
information,
correct, sir?
that's
You're
when
familiar with him?
we
You're
went
familiar
back
with
to the
how
house
he
together and made,
portrays his emotions on his
evidence
face?
went out with,
And in this situation, had you seen emotions like shock
Police
before on
officer
his
noticed,
face?
looked at Ronald, saw his shoes, saw his legs, what that, put put him in custody. Yeah, put him in custody. And while I was in front of him, yes, we did talk. If I saw it, because I asked the officer, I didn't. That's one.
Now, so before your son was arrested, did you and the deputy have a conversation in the front yard? Do you recall talking to him at all and expressing your concerns?
Outside discussing where your mother might be.
What were you concerned might have happened?
Speak to the deputy by yourself. Now, eventually the police came to the home, right? Did your son ever exit that home? Did he exit the home before the police got there? When did he come out and do?
May I have a moment, Your Honor?
Sir, the truth, when you spoke to the police, you described your relationship with your son as estranged. Sir, I don't answer questions, I ask them. Did you understand my question, sir? Okay, now, isn't it true that prior to that day, you hadn't spoken or seen your son in over a year? What's the question? Thank you. Any redirect?
I have no redirect, Your Honor. May this witness be excused so he can witness the rest of the proceedings pursuant to the victim's rights act?
Next steps in what this witness.
Any objection to that? All right, you may step down, sir. You may remain in court.
At some point, did the deputy go to his
Court recalls the case of people versus
Did he ask him to step outside?
Ashley Phelps with people.
One minute, please, Court. Kareem Johnson on behalf.
Thank you.
Skipping ahead a little bit,
Ready to
did
proceed.
you and the deputy have a conversation in the front yard? What, if anything, did you express to him at that time that concerned you?
Sir, please come forward and be sworn.
What did you notice?
Someone swear to affirm the testimony about which state your first and last name correct.
Thomas Ross, THOMAS, RAAP.
Any main question?
Thank you. Good morning, sir. How are you employed? How long have you been a detective with the Washington County Sheriff's Office? Were you employed before that with the Sheriff's Department? In what capacity? Do you have prior law enforcement experience before you came to work for the Washington County Sheriff's Office? Were you working for the Washington County Sheriff's Office on May 17, 2024? Recall what day of the week that was. Were you dispatched to 1315 South Warner in Ypsilanti Township, Washington County? Why were you sent to that address?
Your son was arrested. Did you and the deputy have a conversation in the front yard?
Stating they requested some assistance checking on
Talking to him at all?
Had you done a welfare check for an elderly person before? When you arrived at the home, were there any people outside?
Speak to the deputy by yourself.
Did you speak with them? Who did you identify them to be?
I identified as Ronald Fleming. He was the son of the eligible subject check, welfare check. The female was a Tony Curry. She is the subject's sister.
Did either of them give you a key to go inside the house? Who were you looking for?
May I have a moment, Your Honor?
I'm going to ask you a series of questions to describe the layout of this house. How many doors are there to this home? Yes, how many exterior doors?
There's the front door, front of the house, street side.
During the tour, when you spoke to the police, you described your relationship with your son as estranged.
Is that adjacent to a driveway? Are there any other buildings on this property besides the home?
Did you understand my question, sir?
Is that in front of the home or behind where the home is located?
Okay, now, isn't it true that prior to that day you hadn't spoken?
Did you check these doors?
Your son over a year.
Did you check the screen doors? What did you find about the screen doors and the regular doors? Did you open the screen doors with something?
But informant screens were often asked, like, they were find by or some baseball, try not to cause any damage so we could access the interior doors, which I did.
Did you check any of the windows? What did you notice about the windows?
Windows on either side of the front door, as we're facing the front door, one to the left, was unlocked.
Was it closed at the time that you contacted it? And when you opened the window, did you hear anything? What did you do next?
I announced myself, I called out the sheriff's office, the dog was barking at the dog, ran up to the window, so I showed them, trying to bite him, so I closed the window.
Were there any cars in the driveway? Were you able to identify whose cars they were?
Active was back in the driveway, tried to identify his David Fleming's car. And then there was a black sedan that moves in on the street. And Ronald Fleming said that was his car.
Did you call for any help with the dog?
Yes.
Were you working for the Washington County Sheriff's Office on May 17, 2024? Recall what day of the week that was.
Did you use the key to make entry into the home? Which door did you go in?
Your son was arrested. Did you
At this time, was the animal control officer present? After the dog was taken under control, did you actually go inside the home? Can you describe the layout of this home to the court, please?
It's a single story, ground level home. Has a big space. At the front of the home, there's a living room and a kitchen. On the first floor, then just goes back. There's 2 bedrooms and a bathroom. Bedroom on the I'll get myself these directions. Walk in the front door in the back right side of the bedroom, and then towards the back left is another bedroom that was arranged as an office kind of office.
I'm going to ask you a series of questions to describe the layout.
You mentioned there was a basement. Did you go in the basement as well?
Yes, on the exterior floor.
Where did you start going through the home when you first made entry?
Side door, I walked in and announced myself. I was in the sheriff's office.
Is that adjacent to a driveway?
Walked through the first floor and made my way towards the back bedroom. Looking for the checked that bedroom and find bed and some, pieces of furniture, some walls. And then kind of went around almost like in a circle, checking the bathroom office.
Find any people on the first floor? Did you go to the basement? What happened when you went to the basement?
Basement, Mr. Ronald Fleming at the house was and said they will have it downstairs. Yeah, the door to the right is a closed door that was set as a backup. So I checked the rest of the basement and announced myself against the sheriff's office. I knocked on the door, didn't receive an answer. So I
You made a reference to Mr. Ronald Fleming. Was that the defendant you were speaking with, or was that somebody else?
Was it closed at the time that you contacted? And when you opened the window,
Once you were in the basement, did you find anybody? Who did you find in the basement?
what did you do next?
Do you see that person in the courtroom today? Can you please tell me where he's sitting in an article of clothing that he's wearing? Your Honor, may the record reflect that the witness identified this defendant.
That objection record shows forward.
Identify whose cars they were.
Did you speak with the defendant? What did you say to him?
So I told her, and so the other members were called, and they're all trying to go. She was, I asked her to go upstairs, I step outside, ready to go.
Where did he go when you asked him to step outside?
Upstairs to the first floor, and then on the side went to the driveway.
Did you use the key to make entry into the home?
Did you go back outside as well?
Which door
Did you check any other areas of the property after you went back outside?
At this time, was the animal control officer present?
Inside, behind
After the
the
dog
garage,
was taken under control,
behind the house, there's
can you describe
a
the
small
layout of
lawn,
the home?
tree, around it, side area, black
Did you notice anything about the yard?
Right behind the house, kind of a small patio, first floor, and there's a garden, shrubs in it, there's a tree in the middle. There's a wheelbarrow and shovels sticking out of the ground next to one corner of the garden. In that particular corner of the garden, a large patch of bare dirt.
Were you able? Please go ahead.
You mentioned
said
there's a
that.
basement. Did you actually go in the basement as well?
There's nothing growing there.
Yes, on the exterior. Where did you start going through the
At this
home?
point, had you found Theodore anywhere in the house, in the garage, or any immediately visible area of the front or backyard? After the defendant went outside, did you speak with him as well as Miss Tony Curry and the defendant's father? And who did you understand that the defendant was to Theodore? How were they related? What did he say the last time he saw her was?
Mr. Fleming, I'll say, Mr. Fleming.
That's fine, or the defendant, whatever please you.
Find any people on the first floor?
At first he said, a few days ago, I asked him to try to narrow that down. He told me that gone with the individual that was working on Monday, but last week, they were Wednesday. I'm trying to narrow it down a little further. I asked him what time of day, he might have seen class. So I believe it was the evening, and sounds like Tuesday.
You made a reference to Mr. Ronald.
Did you say if anyone else had been in the
Was that
house?
the defendant you were speaking with, or was that somebody else?
Did you ask him about Theodore maybe going for a walk? And what did he say about that?
And when you opened the window, once you were in the basement, did you find anybody?
Stooped over, or pushed back, and she was all the way, she commented
Did you see that
driveway.
person in the courtroom today?
She tried to
Can you please tell me where he's sitting in an article of clothing?
After you spoke with all of these people, did you do any checks to see if Theodore had been transported to a hospital by
Your
ambulance?
Honor, may the record reflect that the witness identified this.
dispatch, asked me to call the local hospitals, trying to be
Did you speak with the defendant?
or also St. Joe's, and University Mission Hospital. I also asked for dispatch to check the ambulance service, and I also went personally checked on the in-car computer, for any call from my head.
Any positive results?
I've been checked in the hospital situated, not the ambulance support. We had to have a call through that.
When you say a very long time, what time frame are you talking about?
I'm not sure how long that is, but
Did you
more
go back
than.
outside as well? Did you check any other areas of the property after
When you determined that she had not been transported to the hospital and was not at the hospital, did you do any other investigation?
I asked asked Ms. Curry to call his cell phone. Ms. Curry previously told me she tried calling her and texting her and had received an answer, so I asked her to call again. Phone's right there. See if my phone maybe.
What happened when you asked her to call the phone? Did you look at the phone? What did you notice about the status of the messages and calls on your phone?
Emails, phone calls, text messages, and it seemed like all of the phone calls and text messages stopped and server open to manage or replies to them.
Where did you put that phone?
At this point, did you found either anywhere in the house, in the garage, or
After putting the phone in your patrol car, did you speak with Ronald Fleming Sr.? Without telling me what he said, did you go back to the house again?
as well as Miss Tony Curry?
And what were you doing when you went back to the house for that second time?
And who did you understand
The
defendant was?
look around again, just trying to see that.
What did you say the last
Instead
time
of
you saw her was?
Did you ask the defendant to handle the dog at that time?
Aggressive dog.
That's fine, or the defendant, whatever, please.
I asked him to secure the dog. The dog's inside of the house.
Had the animal control officer left at this point? So you asked the defendant if he could secure the dog so you could search again?
On the driveway, there's a dog road, but it's chain link fence. Secure the dog there.
Can you describe the fences that existed around the driveway area so the court can have an idea of what this is like?
There's about a 6 or 7 foot chain link fence that touches the wall of the house, goes across the driveway, and goes back 6 or 7 actually the detached garage. And the detached garage on the back of it is connected to the property line fence. And then if you're trying to go from the backyard to the driveway, there's about 4 feet fence that
And that fence that's between, the sort of that goes across the driveway before you get to the door, is there like a gate in that fence? There's a gate.
Goes across the driveway before you get to the door.
Did the defendant, Ms. Curry, and Ronald Sr. consent to you going back into the home? Did you find anything of significance inside the home when you went back to the gas?
Defendant, Miss Curry, and Ronald Sr.
I found anything. All we said was Ms. Curry, Mr. Fleming Sr. coming to see the take down. Theatrics, house keys and Ms. Curry. And they also brought out, and my Theater brought out laptop and typing.
So at this point, what of Peter's possessions have you been able to identify as being at or near the home?
House keys, phone, I need credit cards, case, a phone case that had slots on the back, so I can also with the phone. Case, card, house keys, phone keys, phone on the back. Laptop I use.
Now, at this point, where was the phone located at this time during your search?
Where exactly the phone was, because only the outside to retrieve the phone was ringing and I didn't know where to, so I didn't see where the house.
And you had secured your patrol car? So at this time, was it still in your patrol car? Did you go to get it? As you walked outside of the home, what if anything? Did you go to get it? As you walked outside of the home, what if anything?
I had been kind of pulling my hair out, figuring something about it, because that was a big event. I've been on a lot of over checks. Every welfare check I ever done, I've been on a lot of checks. I was ready to call it quits. I didn't know what it was. Thought I checked every box, everything. I discovered that part told me that Deidre must be there in that house, but she wasn't there. No,
Did you recall anything about your search?
Discovered that part told me. They called me out to the phone already. She wasn't there.
Did you recall anything about your search?
God spoke to me and told me, don't turn around, she's here. The sunlight had a lot of thoughts, a lot of recollections. And all of a sudden, I was here. I remember the sun right in the backyard, patching freshly up turned dirt, showing me down the ground next to it. I remember when I was patching freshly, how weird it was to he just grandson would be in the house for how many days, 2 or 3 days. Nobody else had come to the house. There's no signs of forced entry. Theater was conducted. The door was protected. The doors were all locked inside. All the car was there. The phone was there. The keys were there. Her friends in the living room with her texting the phone, the messenger on the phone, you know, are you okay? She was at the hospital. There's everything he said. If she's anywhere, the messenger was at home. So I thought, worst case scenario, what could be the answer to this? The only person that was there for the worst case scenario, bottle place. If she's nowhere to be found, the only person the only place that my brain goes to, maybe she was killed there. She would, if I killed somebody, where would I hide a body else?
You said Ronald Fleming Sr. Did you mean Ronald Fleming Sr. was the only person?
She would, if I killed somebody, where would I hide a body else?
You said Ronald Fleming Sr. Did you mean Ronald Fleming Sr.?
So I asked myself, if I was going to kill somebody and hide a body, where would I put it? I was very good. And I remembered the freshly patched up turned very backward. How I dig a hole, it was a shovel. It was a shovel sticking out of the dirt. If I'm not myself, I have to move a body. How would I do it? Sit down, patch dirt. I walked back into the fence on the dog was harder at me. But to the other side, I walked into the backyard by the garden and I saw the patch freshly upturned dirt there. Stepped on it, foot. It was hard packed around the edges like the dirt hadn't disturbed in the middle. It was soft. Slightly sunk in. That section that was soft, slightly sunk in, was roughly 6 feet by 2 feet. It was the size of a body, 7th grade. So I grabbed the shovel and I started digging. I dug for a little bit. Picked something that wasn't a rock, it wasn't poured dirt, it was something softer that the shovel struck. Kind of scraped the dirt with the shovel a little bit, saw something, cloth or a piece of sheet sticking out of the dirt. So I threw the shovel down, I threw down on my hands and knees, and I started digging with the gas. Grabbed the sheet, pulled it back, and I reached up my hand, and I grabbed what felt like human length, like an arm or a leg.
What did you do after you grabbed yourself? What felt to you like a human arm or leg?
The defendant carries her back up my stuff on my hands now. Got on the radio, I called for them to come to my location. So I went back over the fence, back to the front of the house, and do the best way how to go about it. So just for time, just taking away. Got it. Try to buy some time for sport games.
Where did you go in the house when you went back inside? What area of the home did you end up in to speak with everyone? Where did you go in the house when you went back inside?
Kitchen.
What area of the
Kitchen
home
at
did you
night.
end up in to speak with? Like an eat-in kitchen? And who all was in there?
Kitchen at night.
Like an eat-in kitchen? As you were standing in there, did you talk with everybody? How long did you speak with them, if you recall? As you were standing in there, did you talk with everybody?
Maybe 5 minutes.
How long did you speak with them? At some point, did you decide to arrest the defendant? And did you place him in handcuffs? Did you search him and put him in the back of your patrol car? Did you question him at all? Did a sergeant arrive on scene? Did you search him along with many other people? And at that point, did you turn over your investigation to other members of the sheriff's department?
Did you search him along with many other people? And at that
May I have one more, Your Honor?
did you turn over your investigation to other members of the sheriff's department? Did you search him along with many other people? And at that
May I have one more, Your Honor?
did you turn over your investigation to other members of the sheriff's department? Did you search him along with many other people? And at that
May I have one more, Your Honor?
did you turn over your investigation to other members of the
Cross-examination.
Good afternoon, Deputy. You go to this location because family called you concerned about the whereabouts of a family member. You get to the location. You go to this location. One of the family members family called you concerned about the whereabouts Ronald Fleming Sr. Family member. You get to the location. You go to this location. Did you ask Ronald Fleming Sr. if he lived there? Ronald Fleming Sr. Did you ask Miss Curry if she lived there? Did you ask Mr. Fleming Sr. for identification to check his address? Ask Miss Curry if she lived there. Did you ask Miss Curry for identification to check her address? Mr. Fleming Sr. for identification. Miss Curry provided you with the key. Miss Curry if she lived. Did you ask Miss Curry if she had authority to enter that location? Miss Curry provided you with the key. Did you ask Miss Curry if she had the authority to give you permission to enter that location? You took a screwdriver and forced entry into one of the screen business into that location. You took a screwdriver and forced entry into one of the screen. So you forced entry to access the door that you can use the key. At some point you enter that location. You don't have a search warrant to access the door that you can use the key. And you don't have permission from anybody you know to live there into that location. Search warrant to access the door. The purpose of you entering that location was to check to see on the well-being feature. The purpose of you entering that location was to check. Washington Sheriff, there is a policy on welfare checks feature.
Yes.
Are you familiar with that policy? Washington Sheriff has a policy on welfare checks feature. The purpose of a welfare check, would you agree with me, is to see one, if the individual is there, and two, if they need medical assistance. The purpose of a welfare check, would you check the home, is to see one, if the individual is there, and two, if they need medical assistance. The purpose of a welfare check, would you check the home. So therefore, there was nobody to render medical assistance to. Correct? Medical assistance. The purpose of a welfare check, check the home. So therefore, and at that point, to render medical assistance to, you did see Mr. Fleming, correct? So therefore, you asked Mr. Fleming to come outside. You did see Mr. Fleming, correct? That was not a order that Mr. Fleming could resist, correct? You did see Mr. Fleming, correct? That was not a order that Mr. Fleming could resist, correct?
He said it was an ask, but he also said it was an order, so I'm not really clear on what the question.
Overruled, I think it's clear enough. Go on.
He said it was an ask, but he also said it was an order, so I'm not really clear on what the question
I guess I'm lying to say.
So it's your testimony if Mr. Fleming Jr., the defendant, would have told you, no, get out of my house, you would have just left? So it's your testimony if Mr. Fleming Jr., the defendant, would have told you, no, get out of my house, you would have just left? So it's your testimony if Mr. Fleming Jr., well, yeah, I would have. So now you are no longer doing a welfare check, you're now doing a criminal investigation.
He said.
Sustain that.
Okay. What other investigation would have turned into? No longer doing a welfare check, you're now doing a criminal investigation. What other investigation would have turned into? Welfare check, you're now doing a criminal investigation.
They're still ownership of the residents in the property, but they haven't looked at it. Probably would have gone back outside, have their still ownership of the tell me what happened. I guess asking him what he said back outside, have their still ownership question.
My question to you was, Ronald Fleming Jr. would have told you, no, I don't want to leave the house, and to get out of my house, would you have left? Ronald Fleming Jr. would have told you, no, I don't want to leave the house. I don't think he'd be speculating on what his behavior would be. I could ask him what he would do under a certain circumstance.
Well, he's speculating because the premise is what he would do under a certain circumstance.
When you are questioning Mr. Fleming, you have him ask him to leave the location. correct? Questioning Mr. Fleming. You have him ask him to leave the location. But you didn't have him just go upstairs, you had him go outside. You have him ask him to leave the location. But you didn't have him just go upstairs, you had him go outside. And by going outside of the location, you had Mr. Fleming Jr. go from a location in which you could not make a warrantless arrest to a location in which you could make a warrantless arrest. Jr. Correct. A location in which you could not make a warrantless arrest. It goes into a location in which you could. To Mr. Fleming being in custody and whether or not this officer is acting under the exigent circumstances exception, or if he's doing a criminal investigation inside a home without a warrant. And whether or not this officer is acting under the exigent circumstances exception, or if he's doing a criminal investigation inside a home without a warrant.
I don't know that it necessarily goes there all over. I'll allow it. Go ahead. But go ahead. I don't know that it necessarily goes there all over.
By having him leave the inside of the residence, you had Mr. Fleming Jr. go to a location in which you could make a warrantless arrest outside the home. Inside of the residence, you had Mr. Fleming Jr. go to a location in which you could make a warrantless arrest outside the home.
Actual location.
At this point, after speaking to Mr. Fleming, you now realize that Mr. Fleming is the only family member present that actually lives at this location. At this point, after speaking to Mr. Fleming, you now realize that Mr. Fleming is the only family member present that actually lives. After speaking with Mr. Fleming, you now realize he's the only member of the family present that actually lives at that location. After speaking with Mr. Fleming, you now realize he's the only member of the family. Defendant Fleming Jr. Yes, yes, sir. Lives at that location.
As far as I know,
You're speaking member of the family. Defendant Fleming Jr. Yes, yes, sir. When you began to question Mr. Fleming Jr. outside the residence, was he free to leave? When you began to question Mr. Fleming Jr. outside the residence, was he free to leave?
Other than having at that precise moment in time that came up from the basement, I was shocked and surprised and strange feeling that got about the one found asleep in the basement, but stayed up and surprised and strange feeling that got about the one found asleep in the basement, but
and at this point, you are now suspicious as to the whereabouts of Cedric. And at this point, you are now suspicious as to you still have not seen or located her at this residence. And you haven't located anybody in the residence that needs medical assistance or emergency aid. You ask individuals to go back into the home again. Assistance or emergency aid. Correct? You asked individuals to go back. How many minutes went by when you asked, by the time you asked to re-enter the home and search? You asked individuals to go back. How many minutes went by when you asked, yeah, how many minutes was that? Re-enter the home and search. You asked individuals to go back. How many minutes went by when you asked, yeah, how many minutes was that? Re-enter the home and search. You asked individuals. Did Mr. Fleming Jr. ever give you permission to grab that shovel and dig in that backyard? Did Mr. Fleming, did you have a search warrant to grab that shovel and dig in that backyard? No further question. Did Mr. Fleming, did you have a search warrant to grab that shovel?
All right. Thank you. Yes, sir.
No further question.
Aaron Sawyer.
Did Mr. Fleming, did you have a search warrant to grab that shovel?
All right. Thank you. Yes, sir.
No further question.
Aaron Sawyer. This witness has finished his excuse. Is that correct?
Objection. No, Your Honor. All right, this witness is excused.
Thank you.
Yes, sir.
No further question.
Aaron Sawyer. This witness has finished his excuse. Is that correct?
Objection. No, Your Honor. Please come forward and be sworn.
Thank you.
Yes, sir.
No further question.
Aaron Sawyer. This witness has finished his excuse. Is that correct?
Objection.
Right, we saw you sort of from the testimony about the gift. Oh, you did not do it. Yeah. I did.
State spell your first last name for record.
AARY. You may record.
Good afternoon, sir. How are you employed? How long have you been a detective with the Washington County Sheriff's Office?
You may record.
Good afternoon, sir. How are you employed?
Do
Do you have any prior law enforcement experience before you were employed with the Sheriff's Office? No. Were you working on May 17th, 2024? Were you dispatched to 1315 South Warner Road in Ypsilanti Township? What purpose were you sent to that address? No.
I've been notified that I had.
On May 17th, 2024?
Sales assistant team detective with a search warrant. Specifically, it was my task for the evidence, the garage and surrounding property.
And was the search warrant obtained for the residence? And when you got here, what was your responsibility?
I kind of assisted Tex Roberts with my checks across the scene. So I brought a physical copy of the search warrant out there prior to the search taking place. I did have some part to play in that yard where the seating was open.
Which part did you have to play in that?
So we had involved Martin had involved the initial safety anthropologist and Hannah Field in there. She had requested that we verify it wasn't that human remains that were present as opposed to the animal. So I found a little bit more of the dirt around what appears to be a white bag with white cloth material. And then I used a sterile scalpel, well, can't base the sterile scalpel to create a put into that fabric. When I opened that up, peeled inside, and I saw an additional layer of fabric, which was a red and yellow float-like blanket. And then did the same with this layer of fabric, cut it, and peered inside, and I saw one beard complexion of
What body part were you looking at?
the lower legs. And then did the same with this layer of fabric, cut it.
After you confirmed that there were human remains in the ground, did you contact any other members of the Sheriff's Department?
Yes, so I should say, right in the beginning, with the fabric, it did feel what appeared to be human remains that were cold touch, and it did feel the shin area from the head. After discovering this, I actually was on the phone with Detective Morrison and Ryan at the time, but I did relay my findings to them as well as contact the additional law enforcement at the Sheriff's Office. So they're currently conducting an interview.
Did you return any physical evidence or items from that location to the Sheriff's Department?
I collected a cell phone that belonged to the teenager employment seated in this case. This was already collected by Defense Roberts and was back control for government issued vehicle, I should say. I also collected a cell phone that was on the steps on the west side of the home. So this was if you're looking at the house from the street, this would be on the left side of the house. This was believed to be a cell phone. I also collected a cell phones and other electronic devices were on the cell phone site, collected that, transferred it back in the Sheriff's Office, and turned it over to our computer forensic.
After taking those items to Station 1, is that correct? Went to Station 1? Which is located in the same building where we're at now? 2201 Hogback. Did you return to that Warner Avenue address? Did you stand by at the scene for some time?
For several hours, during the search by Detective Roberts as well as the station personnel that responded. I also was present for the exhumation of the body from the identified grave.
Did you eventually attend the autopsy a few days later?
May
I have a moment, Your Honor?
I also was present for the exhumation of the body from the identified grave.
Did you eventually attend the autopsy a few days later? Pass witness.
Cross-examination. Good afternoon, sir. When you went to the location, did you have a search warrant? Or when was that search warrant signed?
with Mr. Time was signed on May 17th by
Cross-examination.
the exhibits. That's prior to the search of the property.
When you went to the location,
did you have
it was
search
prior to you digging into the
When was that
digging into the
search
bag.
Prior to me entering the property or digging into May 17th, by that time period, the exhibit had already been signed prior to.
Who was the affiant on that search warrant?
When you went to the location, did you have
It was prior to. Where did you get the digging into the probable cause facts for the affidavit search warrant?
So I obtained the cause for
Who was the affiant on that search warrant?
Where did you get
the welfare check to 1316, believes that
The affidavit search warrant.
as well as from a phone conversation that was heard by Martin John speakerphone with Sergeant Hilton.
And so those were the only sources of information for your affidavit.
As well as from a phone conversation that was heard.
Thank you. No further question, John.
Hang on, I'm gonna be excused.
Yes,
And so those were
you
the
may
only
step down.
sources of
Thank you,
information for
sir.
your affidavit.
Please come forward and be sworn.
As well as from a phone conversation that was heard.
Thank you. No further question, John.
Sound short from
testimony about the evidence, the truth, the whole truth, and nothing but the truth, so help me God.
Please come forward and be sworn.
State, spell your first and last name for the record.
Inspector Charlie Morrison, issue DHR.
Testimony about the evidence, the truth, the
Remain
whole
quiet.
truth, and nothing but the truth.
Good afternoon, ma'am. How are you employed?
Back to the Wild Fire Process.
How long have you been employed as a detective?
Since 2020. Issue DHR.
Do you have prior law enforcement experience before you were a detective?
Yeah, which was the,
How long have you been employed as a detective?
19 years. Since 2020.
Were you working on May 17th, 2024? How did you become involved with an investigation into the homicide of Deidre Fleming?
19 years. And, so they believe that,
May 17th, 2024? And did you respond to the scene or do something else?
Initially spoke with, the team, let them know, that's when we got the information from Detective Chartering, we FaceTime. Well, first we reviewed the Detective Ross, body camera, got the information, got the search warrant signed. Then we found that, the defendant came back to the station, wanted to be interviewed, so we had the camera out, got the body discovered by Detective Chartering, then I interviewed the.
Where was the defendant interviewed?
Number 3,
Were you able to identify, are you able to identify the person that you interviewed on May the 17th, 2024? You see him in this courtroom? Can you tell me where he's sitting and what he's wearing? Were you able to identify, are you able to identify the person? Your Honor, may this record reflect the witness identify the defendant?
Yes, sir, we put this up.
Was the defendant read his Miranda warnings? Did he waive those rights and agree to speak with you and Detective Reisanen? Did he say how long he'd been living at the address? Was this time said? How did he describe her physical condition? Did he say how long he'd been living at the address?
She had rods in her back and neck, and then she had complete OPD.
How did he describe her
And she would not be able to make it choosy depending on the driveway if she had to walk.
When asked about Theodore was, what did the defendant say at first?
And then she had complete OPD.
Did he say when the last time he saw her was?
Make it choosy depending on the driveway if she had to walk.
When asked about Theodore was the defendant questioned about any digging or other activity that had happened in the backyard? Did he say when the last time he saw her was? And how many people did the defendant say had dug in that backyard?
People that have access to the backyard today were,
Questioned about
that his knowledge,
any digging or other
himself,
activity that had happened in
and
the
maybe
backyard?
Deidre did a little.
And how many people did the defendant say? Had anyone else been in the backyard digging to the defendant's knowledge? Was the defendant ever confronted with information about what had been found by law enforcement in the backyard garden/flower bed area? How was that done? Had anyone else been in the backyard digging to the defendant's knowledge? Was the defendant ever confronted with information about what had been found by law enforcement in the backyard garden/flower bed
Photographs
area?
that we received from the
How was
state.
that done? At first, did he claim any knowledge of what had been found in the garden or flower bed? What did he say?
photographs that we received from the scene.
Eventually,
First, did he claim any knowledge of what had been found in the garden or flower bed?
did you discuss what was found in the flower bed? You and Detective Reisman with him? What did he say after that happened? Did you discuss what was found in the flower bed? Did he ever tell you how Theodore had gotten into the flower bed?
What did he say after that?
What did he say?
Did you discuss
Out there after he had killed her.
Did he ever
Did he describe killing her?
to the flower bed?
What did he say about that?
What did he say after that? What did he say?
He said that on Tuesday morning, his grandmother had come downstairs. I guess they should back up and say that earlier,
What did he say about
Monday, they
that?
had gotten into a little bit of an argument about what happened at the vet. She got from the vet, talking to him about getting a job with like at school. This made him feel like his grandmother didn't love him anymore. He felt that way for a while.
You said the vet. Let's stop there for a second with that. You said something about Monday at the vet. What happened Monday? What did the defendant say happened Monday at the vet?
He said that Peter got upset with him because he was laughing. The dog, which is his big dog, he's uncontrollable.
What happened Monday? And they had gone to the vet with the dog? What happened while they were at the vet?
The defendant had a whole thumper on the dog, had a whole thumper, that he wasn't sedated properly. And so Peter got upset, and Ronald ended up storming at him by breaking Peter's leg.
What did he say happened later on Monday?
Him getting a job.
And anything else that happened that said between the two of them?
What did he say happened later on Monday?
What about Tuesday? Anything that he said happened between the two of them on Tuesday?
Peter came downstairs,
And anything else that happened that said between the two of them?
from after school again. He said that Peter had a knife in her hand, and that he came out of his bedroom. She was standing in the threshold towards the door. Kind of just with her hands, the way that he did it, he was just kind of like her hands on her hips, as the grandmother would.
You just made a motion with your arms that I want to describe and make sure is accurate. You sort of closed your hands and placed the tops of your hands on your hips with your elbows out at an angle. Is that correct? Does that describe the way that you said Theodore was holding her arms?
Describe and make sure is accurate. Sort of close your
Displayed it
hands
and then
and place
Very good. What did he say happened after that?
on your hips with your elbows out at an angle.
He
Is
came
that
out,
correct?
and
Does that
then he
describe the way
continued
you
their,
said Theodore with your
quote-unquote,
arms? Describe and make sure is accurate.
What happened next?
he says that he was one sitting, he grabbed her, spun her around, disarmed her.
When you say disarmed her, what do you mean?
He did a reenactment towards the Detective Reisman.
What happened next?
He said that he knocked the knife out of her hand.
What did he say he did after he knocked the knife out of her hand?
He put her in what I would call a very choke. So he demonstrated putting his arm around Peter's neck.
What did he say he did after he knocked the knife out?
And that she was able to escape from that. And she turned towards him and tried to claw his face. So he grabbed Peter around the throat, hooked his hand, and strangled her until he cut her neck. And she turned towards him and tried to claw his face. So he grabbed Peter around the throat, hooked his hand.
Did you ask him if he had been hurt during this at all? What did he say?
He said that he has been scratches on his arm, on his lower back. He also gave alternative explanation for it, that either being the dog had scratched him on a Monday. He at one point said maybe the knife that he recanted that it wasn't the knife that the dog had scratched underneath.
You described a few moments ago that he had put her in what you called a rear naked chokehold. Could you describe exactly the positioning of their two bodies that he said that they had while he strangled her with his arm?
So the rear naked choke for me
You described a few moments ago
would
that
be
you were in what you called a rear naked chokehold.
his
Could you
arm
describe
was
exactly the
below her
positioning
neck,
of their two bodies that
coming
he
around
said that they
putting
had
off the
while he
airway,
strangled her with his arm?
where the neck Her back would be against his chest, so she would be facing away from him and he would be directly behind.
What did he say happened after Theodora? Well, he said he strangled her until he felt her neck snap. What happened? What did he say happened after that?
He drove her down into the back of the basement, where we were just like
say happened
the
after
storage
Theodora?
when I
He said he
cellar
strangled her
area,
until he felt her neck
kind of
snap.
a area with shelves. He laid her against the wall, and then later he put her on top of the book, and then he waited until it got dark, and then he drug and carried her up the stairs. His explanation for that was that he was heavy. He went outside, and in the area where the guy had been previously dug up for hostas, other plants. He just left her laying there on the ground and then dug the hole so that her sitting on where she could fit in.
May I have a moment, Your Honor?
He just left her laying there on the ground.
Cross examination.
Good afternoon, ma'am. How long have you been a detective? So you've been trained on taking statements from suspects in custody. One of those things you've been trained on is when the suspect's in custody, before they can be interrogated, they must give a waiver of their Miranda rights.
So you've been trained on taking statements.
And that waiver you've been trained has to be voluntary.
You've been trained on is when the suspect's in custody, before they can be interrogated.
The individual has to understand the rights that they are waiving.
So you've been trained on taking statements.
And was your testimony before this court today that when you saw Mr. Fleming Jr., the defendant, were you able to observe him?
Individual has to understand
You able to observe his mannerisms? You were able to observe his speech? And you believe that he was of competent mind to waive his Miranda warnings?
Who objects to that?
Sustained.
Were you able to observe him?
That's a very nice question. Go ahead.
Did you believe that he understood his Miranda warnings?
And you believe that he was of competent mind to waive his Miranda warnings?
You didn't see anything to alert you that he may have some sort of mental illness or mental situation prohibiting him understand those Miranda warnings?
He had some college education, that he had not been drinking, and that he had stopped smoking marijuana since he was 15.
And at this time, I'd ask the court to take judicial notice that Mr. Fleming Jr. has been found incompetent. He was at the forensic center, I believe, according to the court file, for close to a year.
And at this time, I'd ask the court to take judicial notice that Mr. Fleming Jr.
That he's since been restored.
Since been restored, thank you, absolutely.
But you're asking me to take judicial notice of the competency time frame?
Yes, Your Honor.
At this time, I'd ask the court to take judicial notice that Mr.
One of the things
But you're not asking me because I took to make a finding, regardless of that, as to his competency on the date and time that he's questioned.
One of the things
No, but you couldn't do that, but I will be asking you to take that into consideration and evaluate the statement. The court can, when evaluating the statement of the defendant, consider circumstances surrounding this. One of those circumstances would be his mental state.
We'll be asking you to take that into consideration.
Yes, but you're asking me, I think, take his competency as a way of indicating that I would be adjudicating his competency on the date and time that he's questioned, based upon what was a finding that happened later.
Yes, Your
I
Honor.
don't think I can do that. Adjudicating his competency.
If that's the court's ruling, you got to accept that. Yep. No further questions, Your Honor.
Can you read it? Okay, you may step down. Thank you. I don't think I can do that. Additional witnesses.
No additional witnesses. Your Honor,
No witnesses.
No further questions.
Your Honor, would you request the court bind over the defendant on the sole count of open murder for the death of Theodore Fleming? I do believe that we have established by a probable cause standard that the defendant did cause her death, and ask the court bind this matter over for further proceedings. I'll reserve any further argument for rebuttal. Open murder for the death of Theodore Fleming.
I do believe that
Yeah, we asked for it to
find over again.
It's going to rely on two reasons. We believe here the warrantless entry into the home of Mr. Fleming Jr. can only be justified under the emergency aid exception. Now, the emergency aid exception allows police to make a warrantless entry into a dwelling in which they reasonably believe, based on specific articulable facts, that some person within that dwelling is in the immediate need of aid. They are not allowed to do anything more than that is necessary to render aid to a person who may need aid. Here, the responding officer, based on testimony here, we can see that the initial entry into the home was under an emergency aid exception. He received information from family members saying that they hadn't heard from a family member for quite some time, that was unusual for that family member, which is important. The court has to determine whether or not it was unusual for this family member to not be in contact with other family members for days in order for the court to render this emergency aid exception valid. And then the officer goes in and does a check to see if there's anybody in the home that needs aid. There is not. At that point, the officer has done everything that is necessary to determine if there's somebody in that home that needs emergency aid. Now this is a criminal investigation. He is suspicious about the whereabouts of the individual who's missing, Deidre, and he is investigating. As part of that investigation, he goes to a backyard. He starts digging. He does not have consent of anybody that has standing or authority to grant consent to dig in that backyard. He digs in that backyard without a warrant. He makes a discovery of the body. That information is passed along to a detective who ultimately gets a warrant, but based on the questioning of that deputy, the substantial majority of the information that came from or that went into the affidavit came from the people who were at the scene and would have come from unlawful digging and warrantless digging into the backyard. So any argument that inevitable discovery would apply to the discovery of the body, I don't think can stand. Your Honor, we'd ask the court to suppress the discovery of the body in this case because the officer clearly acted outside the exigent circumstances exception when he started digging in the backyard. There is no reasonable argument anybody can make that the officer thought that somebody needed emergency assistance when he started digging into that backyard. And the courts have been clear there is no homicide exception that applies to the exigent circumstances warrantless search exception. Secondly, Your Honor, we ask the court to not give any credibility to the statement given by Mr. Fleming Jr. To the detective. I think the court can look at the circumstances surrounding the giving of that statement that my client was not in a position in which he could credibly make a decision to speak to police and waive his Miranda rights. That my client was not in a position in which he could credibly.
Thank you, Your Honor. I will start by acknowledging that I think defense counsel's asked for suppression of evidence based on the lack of a warrant for the initial discovery of Theodore's body. The question before the court, I know the court knows, is of course bind over on the homicide. So I don't know that, I understand defense counsel's request and his argument, but I do believe that the suppression issue will be fully litigated in circuit court.
Yeah, but that doesn't mean that the defense won't raise it at some point, because if I were to agree with the defendant, then there may not be probable cause to find it.
Yes, Your Honor. And we appreciate it coming up, and I anticipated this issue coming up at this level as well as when we get into circuit court. I will say that there is more than one exception that applies and that people would allege apply. First of all, consent. The first initial search of the home when we talk about our consent exception is done with somebody that appears to have authority. Your sister has a key to your house and she hasn't heard from you. She can give consent to a police officer to go in as a community caretaker, as agent of yourself, to look for this person. So I do believe that the search of the initial of the house would be fine for consent, as well as the secondary search. When the defendant, Ms. Tony Curry, and Mr. Ronald Sr. are all asked if you can look again, and the defendant, in fact, locks the dog up in the run and goes ahead and looks. Also, Your Honor, I think that it is important to consider the exigency of the situation. This is an elderly woman. No one's heard from her in days. Her phone is full of missed calls, full of unanswered text messages, emails, all these sorts of things that the Detective Rob did indicate to the court. So I think it's important for the court to consider that there is an exigency element here. We don't know where Theodore is. We're looking for Theodore. At the time that he's speaking with Detective Rob, at that time, the defendant is the only person in the home. He hasn't seen Theodore. He doesn't know anything. He doesn't know where she is. He hasn't heard from her. And it's concerning. We are not sure where Theodore is. I do believe that we have sustained our burden. I think that we do have at least more than one exception to the warrant requirement that would apply here. And inevitable discovery is one of them. Theodore would have continued to be missing. There would have continued likely to be more investigation, more police contacts, more police involvement in this case. So I do ask that the court bind this case over and allow us to proceed to trial in the circuit court.
Yes, sir. If the prosecution was arguing community caretaker actually has a higher burden than exigent circumstance. Exigent circumstance is reasonable belief. Community caretaking is probable cause. And for community caretaking, they have to show that these officers believe that there was an ongoing emergency and a danger to the public. There's clearly no testimony to believe to that. And the deputy testified he did not ask for consent before he started dating. So there could be no consent to that portion. We conceded in our...
would consent to access to the premises have to be every act?
Yes, the officer has to.
What I'm asking is, if you give me consent to go into the house, I don't have to get separate consent to enter the kitchen as opposed to entering the bedroom.
Right. That is correct, Your Honor. And now, consent. Now, he's now dead, not on the court. I didn't agree with a lot with Justice Anderson's really said, but he was not a fan of consent. I actually am.
Go ahead, Trey.
And the aspect that he was not a fan of consent because he didn't really believe that suspects could ever really consent to armed police officers. But he and the courts have always kept consent and made it very narrow and tight. That an officer has to have consent for the specific actions they're engaging in. I agree with you. If an officer asks me to search my home, that includes the bedroom and the kitchen because I can revoke the consent at any time. But if an officer asks me to search my home, and then the officer then goes into the backyard and starts digging up, engaging in action that he has not asked for permission to do, then that would be outside the scope of consent.
But hold on, that's not what happened. Because the officer never leaves. The officer is, it's not as though the officer was in the house, got consent to do something in the house, then walked outside and just went to the backyard. They had already been through the backyard, had gone through. So this was in the house, got consent. Where are you saying, if this court believes that there was consent not only to search the house, but also to search the premises, where are you saying that consent ended?
It is where they needed additional. I concede there was consent to search the house. There was never any testimony of consent to search the yard or the structure that was in the yard. It is our position that the deputy needed additional consent.
Why would he have needed additional consent? Because when they're in the home, they all leave the premises and start walking around the outside of the premises into the yard, right? So you're saying that once he's in, then they come out that he has to have some separate consent?
To dig in the backyard.
Well, no, because once he's there, the digging would be like searching the house and moving a board, and all of a sudden you see something. The issue of consent, I'm trying to figure out where you're saying he needed additional consent.
He needed additional consent to search the yard. He had permission to search the home. He did not have permission to search the yard. And it's our position that the deputy knew it. That's why he didn't ask. He just went back there and started digging. He didn't even ask for permission to search the yard. He did not have permission to search the yard.
But if the deputy believed he already had consent, of course, he wouldn't ask for consent, right?
Well, he didn't testify that he believed that he already had consent. So, I mean, I guess that's something the court will have.
But the actions of what happening are continuation. If one believes that consent was originally given, that he's walking around with the individuals that are giving him that consent. I mean, he's given a key, go into the premises. The three of them are there. The three other individuals
Are in the house, yes.
The house, but ultimately they're all outside, right? And then there is this searching around the premises.
Right, they're not all outside at the time of digging. They're, based on the testimony, and it is our position, the only person that had authority to grant consent was Mr. Fleming Jr. We do not believe that there's facts in the record that would establish by probable cause that this officer could have believed that anybody else had the apparent authority to grant him consent after the moment he discovered that Mr. Fleming was
I believe that a person who hands me the key to the premises has the apparent authority to give me consent to search. Why wouldn't I believe? Why wouldn't that be a reasonable belief?
Your Honor, people give keys to neighbors or family members for, all kind of emergency reasons. That doesn't mean that they can.
But that, as to whether or not that person, there's a difference between whether or not that person exceeded their authority and whether or not the person who is sort of believes they have consent reasonably believes under the circumstances that this person can grant consent to the search.
And Your Honor, I think we get off. We're in separate lanes. We've conceded.
Oh no, I know we're in separate lanes.
We've conceded the initial entry into the house was based upon the apparent authority of a woman that was there. Once the deputy discovered that the only person that lived there was Ronald Fleming, then the apparent authority of anybody else there has now been dissipated. There's only one person who would have standing to grant a search under those circumstances. Now, we can get into.
I'd like to Olson case law on that because I don't think that's true.
Minnesota v. Olson.
Comes in, the deputy comes into the home. He's searching. I find somebody there. Somebody says they live there. I'd like to Olson case law on that because I don't think that's true. You're saying at that point the consent terminates? He's searching.
What I'm saying is the apparent authority terminates. Remember the testimony. The officer didn't ask these individuals questions, ascertain whether or not they had any legal standing in that location. The only person, based on the testimony, that had legal standing in that location was Ronald Fleming Jr. Surely under Minnesota v. Olson, I don't think there's any argument the government can make and that the court could accept that Ronald Fleming Sr. or this other woman has standing at that location. Surely under Minnesota v. Olson, I don't think there's any. So now we're looking at who had the apparent authority to grant the second consent search.
But why was the second one needed?
Because the search had terminated. The first search had terminated.
They hadn't left the premise. I mean, where are you saying it terminated?
When the deputy does not find these, comes back out with Mr. Fleming Jr. and he's given that testimony about him being outside inside for some period of time, talking with the family before he asked again if he could go search. It is our position that that second entry was not an exigent circumstances search. It wasn't a community caretaker search. It was simply a consent search. She was not there. There was no reason for him to believe that she was inside that home and needed aid. But he had consent to search the home, which at that point was given. We are not contesting that. The issue here is the scope of that search. The scope of that search did not exceed to the backyard.
The problem is that the problem with that analysis is the individuals, the officers acting, the individuals who have granted him the consent as they're going around are the same individuals that are going around the backyard with him. That's the problem that or the trouble I guess I'm having with your argument. It's not as though he had never gone into the backyard prior to that. That's not what happened here. At that initial search, you'd have to show me something that initial search, that consent that the officer was acting under only included the physical structure of the house and didn't include the outside, because the factual circumstances of this clearly in my mind indicate that there was also this consent to search the entirety of that premises.
Now, with that concept, it is our position that the courts of higher jurisdiction have taken a separate position in the court. It is the position of the government to show that the consent was valid, what the scope of the consent was, and that the officers acted within that scope. It is not my burden to establish in a warrantless search that the government acted outside the scope.
No, but I understand that part of the argument, but you're saying that at some point it ended or didn't include the outside of the premises.
Exactly.
And I'm asking you, when did that happen? I'm stating what the facts are as I see them, and that is that there was the inside, there's the outside, they're all going around the premises. At no point did that surge stop.
Well, I guess that makes it easier for me. So under the case law, the court has asked itself three questions. Did the officer ask anybody withstanding to grant permission to search that backyard? The answer to that question is no. Did the officer have a search warrant to search that backyard? The answer to that question is no. And so now, if the consent is ambiguous, or there's an ambiguity in the consent, who has the burden of showing that the officer's actions were within the scope of that consent? And that is the government. And here,
you're saying that when they first come to the house, someone hands him a key, the officer goes in, that even apparent authority to the apparent authority that person exhibits granting consent at some point just disappears?
Absolutely. My sister has a key to my house. She hasn't heard from me for my
both can be true, Mr. Johnson. One can have apparent authorities grant that consent, but also there'd be another person that can grant consent. It doesn't make the other, it doesn't negate the other. Both can be true at the same time. Can't they?
I don't think so, Yana. My sister has a key to my house. She calls me. I haven't heard from whomever that lives in this residence. I'm giving you permission to enter. The police enter the location. They see me there. I live there. At this point, no reasonable officer could think that my sister, who doesn't live there, has the apparent authority to continue to grant searches at that location. When an individual who lives at that location is actually present.
But isn't it dependent upon what one's searching for?
No, Yana, the emergency aid exceptions made that clear. The heightened or crime that is suspected or the type of emergency that is suspected has no bearing. Because the courts of higher jurisdiction have always been clear. Go get a search warrant. There is no reason why this officer could not have radioed in and said, hey, we called out here for a welfare check, not find anybody. These are my, levels of suspicion. We need a search warrant to check to search the entire place. And said, hey, we called out here for a welfare check, not find anybody. These are my
Two final things, if I may, Your Honor. The court has received the post-mortem examination report. It does indicate that the cause of death is strangulation in the manner of death was homicide for Miss Deidre Fleming. And the last I'll say is that defense counsel's example about giving his sister a key, his sister calling in a welfare check, and then the police arriving at his home and seeing him is very different than what happened here. Because the subject of the welfare check was Deidre, not the defendant. Thank you.
His sister calling in a welfare check, and then the police arriving at his home and seeing
And I'll settle.
Yes, sir, thank you.
Madam Bride.
Because the subject of the welfare check was Deidre,
They didn't
not the
watch
defendant. Thank you. His sister calling in a welfare check, and then the police
I was looking out for you, and I'll settle.
Yes, sir, thank you.
Madam Bride.
Because the subject of the welfare check was Deidre, not the defendant. Thank you.
Court does call the case, recall the case of the People's State of Michigan versus Ronald Fleming.
Ashley Lonnie Feltus for the people.
Good afternoon, may I please call Kareem Johnson on behalf of Mr. Fleming?
The court has heard the testimony and announcement of counsel regarding the People's State of Michigan versus Ronald Fleming.
Ashley Lonnie Feltus for the people.
Preliminary examination in this case. The issue, and it have to be dealt with as long as the court for the purposes of the search. However, court looking at case law and also just the factual circumstances are a little bit different than anything the court was able to find. But what is very clear is that when the first deputy arrived, that there was given to that deputy consent to search the premises. There's not doubt in this court's mind that there was. And that whether or not that person granting that consent, either one of the two that originally are in this court's mind that there was. I think it was reasonable that the officer believed that they had apparent authority to grant permission for the search of the premises. The question then becomes, and I think it's also important that Mr. Johnson has brought up on behalf of the defendant the issue of standing to challenge the search. And standing is different from that apparent authority or grant of consent. Standing would come into play if there were a challenge to the search, and does somebody have standing to raise that challenge? That really is the customary way that would work, and I don't think that this really would involve a challenge to an issue of standing. And certainly as to whether or not there was proper consent, and whether or not the officer acted certainly in good faith in terms of that consent. I think it's also important to point out, as the court had, that consent, at no point do I see that the officers acted beyond the scope of the consent that was granted. Just on the face of it. They went into the house, but then came out of the house, and at some point re-entered the house. They were searching the house and the adjoining area. There was a walk around in terms of the backyard because the freshly dug portion of the garden area where the decedent was found was indeed noticed by the officer at a certain point.
he doesn't do anything with it at that point, but it's still going around. And the court, in terms of the court's notes, it is correct. There's other information being given to the officers that are there. For example, that we can't find a decedent. We've done all the calling around to hospitals, ambulances, seeing if there are calls for service. There aren't any. But then at some point they're given her house keys, car keys, her phone is obviously there. There are, her vehicle is there, and she's not anywhere that they can see. And certainly at that point, one can look at it another way. I think under a certain theory they're operating on that consent, but I think also those items are creating certain extended circumstances where these officers should continue doing what they're doing, because we cannot locate this individual. But what appear to be all of their personal effects are there. They're at the house. So something certainly is amiss, and it involves an elderly human being, and they go through that process. So from this court's perspective, I don't think there's an issue, certainly regarding the consent to search and the initial search that was done. Has Detective Robert Deputy Robert that point, upon discovering what discovered, continue doing something, then maybe we get into another issue of whether or not there should have been a warrant for him to continue on. But I don't think his intrusion and the, say, minor digging, but is looking to uncover what this was in front of them in search for this individual that they can't find is beyond what would have been the consent that was granted. But also know the three people there, those in search for court believes certainly had apparent authority from the officer's perspective to grant consent, as well as the person that defendant claims had the actual consent, which I don't entirely agree with, but understand the point. While his deputies doing all of this, no one is objecting at all, which I think is further indicia of the consent that was granted to the officer task. And so, for those reasons, I don't find that the issue of the consent. It was followed up with the warrant with reference to the charges of the open murder outside of the confession of the defendant as to what they did and how they killed the decedent in this case. There is also ample evidence where he's in this sort of curtained out dark house in the basement where the owner of that premises hasn't been seen for 3 or 4 days. He does nothing, does not act, at least apparently based upon this record, does nothing to this court indicates not only that he intended to kill the defendant or kill the decedent and did so, but also intended in some way, based upon his actions of taking the body there. In doing that, he was covering up his criminal activity. So taking all of that into account, and just one other thing, I do not find that there's anything defective in the Miranda warnings given and who it was. Detective Morrison testified that she believed that upon giving of those warnings, the defendant understood those warnings, and that the assessment that she made is that he voluntarily waived those rights, and that he did answer the warning. And so, taking all of that into consideration, taking all of the evidence, including People's Exhibit 1 into evidence, the court does believe people have indeed sustained their burden. In this case, and would find the defendant over on the charge of overtaking.
The evidence included People's Exhibit 1, the evidence the court does believe those people have deep sustained labor. In this case,
Johnson, you acknowledge receipt of the information with
Yes, Your Honor, I do.
your client is standing mute to the charges.
Yes, sir.
Been in every way prone reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set.
May 26th at 1:30 for Judge Punky.
May 26, 2026, 1:30 before Judge Simpson.
reading standing mute, court will enter a not guilty plea. Pre-trial in this matter will be
May I approve the second?
Thank you.
May 26, 2026,
I'm gonna let you know.
1:30 before Judge Simpson. Reading standing mute, court will enter a not guilty plea. Pre-trial in this matter will be
May I approve the
This
second?
Valera gives people a chance. That's consistent with how this court feels. If you mess this up, I'm not going to be making the final decision is mine. I'm not going to at all be consistent with how this any kind of break. If you mess this up,
Good morning, Deputy Court Attorney Daniel Casper, number 858. We have Taylor Byers, Vice Chairman for the record.
at all be consistent with any kind of break. Big time.
Good morning, Deputy Court Attorney Daniel Casper, number 858. We have Taylor Byers. Yes, we PSI report. I have no additions or changes or deletions, Your Honor. I just do at some point want to discuss bond violation that Mr. Byers had in the report that I received.
Well, go ahead.
So, Mr. Byers, I called records at Bear River Treatment Facility about what Travis areas he was admitted for treatment on November 24th. That was Mr. Byers' explanation for why he was not able to test. You understand that he was in contact with, at times, probation. The department informed them that he was in treatment. I'm not exactly sure how that was conversation detailed and how he was completed December 23rd, and they confirmed the records this morning, and I also reported those records to the court.
You can fit it here.
December 23rd, and they confirmed the records this morning, and I also reported those records to the court.
I'm not going to find a violation because I think that the issue is potentially that there wasn't any information. There wasn't anything that was going to fit circumstances. The information was just not flowing. Potentially that was information. So I'm not going to find a violation. I'm just saying a violation is information just not flowing.
He owed him some flowers and things like that.
So I'm not going to find a violation. Okay. Anything else?
Other than I was not accused, I've been in contact with his family, his brother, and they informed me along his siblings. They are, I would say, very interested in his growth and his continued development as he continues to go through treatment. I believe it is very serious to him as well as he admitted to himself. They explained to me multiple times that it is very serious for him to get through his treatment process to better himself so that he really just want to get back to being a productive citizen and back to work.
Sir, anything I want to say thank you for everything you did because you actually helped me in my life, with my life on track. And I only want to do the right thing. I want to be the best that I can be for my son. And I just want to be the best person I can be. And I just want to say thank you for helping me with my journey because I'm on the right path. And I just want to say thank you. Thank you.
Ms. Blair, just so that I can make sure I'm understanding this, the proof of treatment got it.
However, it was brought to my attention, with Mr. Byer was agreed that he advised the court that he was in treatment. And they had a company of attendance and no completion. So, I know he represented the Byer was agreed. I just was not advised.
Right, I think, let's say something. Is this the one that indicated that?
I know he represented the Byer
Was enough.
I just was not advised.
Right, I think, let's say something. Is this the one that indicated that?
I know he represented the Byer
Was enough.
I just was not advised.
Right, I know. It's like down and the proof is a treatment. Yeah. Myself.
Last week when I was here, I gave my completion to Judge. I actually have my completion in my file.
Gave it to who?
Judge Reese. Is that her name? I gave my completion.
Well, we don't have a judge now.
I actually have my completion in my file.
Gave it to who?
I gave her the copy last week and I made a copy of it. It's actually,
I would say, Dan, have to bear with me. The records I received today will be the most up-to-date records that was released this morning, correct? And hopefully that is enough. Because it says on there, it says on there.
Well, which record is it?
The records I received today will be the most.
I actually have the verification of the discharge letter.
Because it says on there, it says on there.
Well, which record is it?
The records I received today
Indicating that he has successfully received the verification. I haven't. Actually, it was one of the other papers that was okay. And that's the treatment you're talking about. Okay. Indicating that he has successfully the one. I have. So I will step to the court. It's going to be $25 statutory. Okay. I'll order 90 days of jail. Credit 61. That he served. The balance that is suspended. I'll order 90 days of jail. Credit 61. Thank you, sir. You have a wonderful day. Thank you. The balance that is suspended. I'll order 90 days of jail. Credit 61. Courthouse State versus Wayne Rankin. Thank you. The balance that is suspended. I'll order 90 days of jail.
Carolyn Foster, talk around behalf of Rankin.
Courthouse State versus Wayne Rankin.
And Your Honor, we have had a chance to review the pre-sentence report. We have no additions, corrections, or deletions. We would ask the court to follow the recommendation. Mr. Rankin did indicate that he needs a payment plan for the restitution and the fines and costs. He said he can make a payment by Friday, $200, and then he believes he should be able to do $200 monthly payments.
And Your Honor, we have had a chance to restitution and the fines and costs.
Yes, ma'am.
He said he can make a payment by Friday, $200, and then he believes he should be able to do $200 monthly payments.
And Your Honor, we have had a chance to restitution.
Anything you want to say, sir, before? Just, well, I don't really have much. I just take full accountability for my actions. Just made a bad error of judgment at the time. I just got back to working for a field property. I was laid off, so that's why I'm not being able to pay anything today. Made a bad error of judgment. Sent to the court $400 fines and costs. I just got back to working. $3,484.87 restitution. The victim in this case payable to the court. Since order 90 days suspended as to payment of fines and costs and restitution, that's to be $200 per month beginning January 16, 2026. I will set a review hearing that will be June 10, 2026 at 9 a.m. to verify compliance. All right.
Thank you, Your Honor.
Thank you. I will set a review hearing that will be June 10, 2026 at 9 a.m. to verify
Ms. Conrad, state your name for the record, please. Be on the call, Barrett.
Thank you, Your Honor.
Today, the date and time set for defendant update. Do ask that the court adopt the record.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Conrad. Ms. Conrad, state your name for the record.
Ms. Conrad has been in custody for quite some time. I would ask for a payment plan to be established with probation on the fines, so she can get out and get back on her feet before starting the payment.
Ms. Conrad has been in custody for quite some time.
You want to say
I would
that
ask
before I
for a
move?
payment plan to be established with probation on
And
the
you know why
fines,
you're here.
So she can get out and get back on her feet before starting the payment.
Ms. Conrad has been in custody for
It's
quite
like
some
you step
time.
different.
I would ask for a payment plan to be established with probation on the
You know
fines.
why you're here. The court acknowledges this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment, attendance at AA meetings, and abstinence from all toxic. Therefore, the court will follow the recommendation of probation. The alcohol screening and assessment is stated to be clinically goals to promote change, treatment, and recidivism, and monitor compliance with treatment. Therefore, the sentence of the court is to be placed on 12 months probation. You're to pay $855 fine to court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. That is to be paid in a payment plan as established by there is to be no use of alcohol, recreational marijuana, or illegal substances and subject to random testing as requested by probation. You're to complete outpatient treatment, including recommended aftercare with status no use of alcohol, recreational marijuana. You're to provide proof of the victim's input panel attendance to probation. You're to attend a meetings with monthly verification to probation. You are to report to probation on January 20, 2026 at 2 p.m. That is in person. And then you're to report as directed. However, 90 jail credit 47 balance is 26 at 3 p.m. That is in person. And then you're to report as directed. However, 90 jail credit 47 those case people versus Redmond. And then you're to report as directed.
I don't believe he written today's hearing, but I was able to meet with him and go over the recommendation, and he would be asking for following.
And so you're indicating that you wish the court to sentence him in absentia on this violation.
Yes, recommendation. I did see him directly yesterday, and he gave me permission in that manner.
All right, and so you're in WA. You wish the court to sentence him in absentia on this violation.
Yes, recommendation. I did see him directly yesterday, and he gave me permission in that manner.
All right, and so you're in WA. In absentia, your sentence is defended 365 days in jail, credit 365 served. He is to pay $545 outstanding restitution balance that will be sent to the Collections Department. I will waive all remaining terms of discharge of court calls case to be sent to the U.S. Collections Department. I will waive all remaining terms of discharge of
Assistant Public Defender Natalie Payton, on behalf of Mr. Stringo, stands to my right. What's your name for the record, sir? Thank you, Your Honor. Take your time, sir. Both cases, we have reviewed both recent investigation reports and do not have any material corrections. And as to the recommendations for each case, we respectfully request the court follow them. Your Honor, take your time, sir. Both cases, we have reviewed both investigation reports and do not have any material corrections. And as to the recommendations for each case, we
sent to the court $145 statutory fee, $251 restitution fine, payable through the court that makes it to the police. I will order 93 days bail credit, 62 days the balance, defendant. the other matter, and ending in 0612, $125 dedicated to $107.94 restitution to max payable to the court. That will also be 60 days after the case. $125 dedicated to $107.94. And then I'll order 90. Credit 62, the balance. That will also be 60 days after the case. Court calls case to reverse there. And then I'll order 90. Credit 62, the balance. That will also be 60 days after the case.
Assistant Public Defender Natalie Lee, with on behalf of Mr. Mays, who stands to my right, please state your name for the record, sir.
Yes, Mays.
For probation, Your Honor, Mr. Mays is before the court today for confrontation hearing. I know that the recommendation that I presented to the court today is jail recommendation. However, I had a chance to speak with counsel and Mr. Mays today. I would ask the court at this time, I would like to give Mr. Mays an opportunity to provide what has been I think that Mr. Mays needs to accomplish. I would like to see where he is at. Given that I ask the court to adjourn this violation hearing February 2026, that Mr. Mays be placed on a screen referral for that habit. And that he stay today and meet with the after this time. That Mr. Mays needs to accomplish. I would like to hear. Yeah. Also like is getting very great for me. So given that order to be followed, and then we'll see where things are at this violation hearing.
Thank you, Your Honor. That is all correct that Ms. Blair stated, and I would like to thank her for this, what's the word I'm looking for, edited intimidation. I apologize, Your Honor. Mr. Mays is also very grateful for the opportunity back into compliance with this obvious objection to this frame tether, and he would ask the court to adopt that recommendation.
Just that I, to prove to the court, I'm on my way to rehabilitation. Of my family, or if I have the work for me to go on and to show that I'm innocent. All right, I'll go on for probation.
So
I'm going to let you know.
That order to be followed.
This Polera gets people in shape. That's consistent with how this court feels. If you mess
Thank you, Your
this up,
Honor. That is all correct that Ms. Blair stated,
I'm
and I
not
would like to thank her
going
for
to the final decision behind that or to at all
intimidation. I apologize, Your Honor. Mr. Mays is also very grateful for the opportunity back into compliance with this obvious objection to this frame tether.
I'll adjourn the
Would ask the court
violation
to
of
adopt that
probation hearing to
recommendation.
February 25th, 2026, 9 a.m. The defendant is ordered to meet with probation today, and I follow Superior Superintendent to my way to today. The defendant is also been ordered to report family any questions on the scram tether today. All right. Show that I'm innocent.
Thank you, Your Honor.
All right, I'll go on for probation.
And then I'll be
This Polera gets people in shape. Does take how this court is very complicated.
Thank you, Your Honor. That is all correct that Ms. Blair stated, and I would like to thank her for
Final decision behind that or to
edited
Good afternoon, Assistant Public Defender Lauren Perrin on behalf of Thomas. Thomas, the record. Your Honor, this is the show cause hearing for money owed. When I spoke with Ms. Thomas a few days ago, we were going to ask for his German. He was in custody, he's out of custody, he's being put back on his feet. However, now that he's back in custody, he's obviously not working, so I just asked to set this out.
What I've been doing, I just referred this to like spring.
Custody, he's obviously not working, so I... Thank you, Your Honor. Mr. Thomas was asking what his bond in this case, if the court has it. I believe it was. Mr. Thomas was asking what his bond in this case, if the court has it. I believe it was.
Well, no.
The court has it.
No, his bond was denied. Then, yeah, so his bond was actually $10,000 on April 30th. Then on September 22nd, 2025, the max was lowered it to 1,010%, which he posted.
Okay, so he's not being held on this case. All right.
Thank you. Thank you. Courthouse case, People versus Larry Evans.
Okay, so he's not being held on this case. All right.
Your Honor, Mr. Evans has been had a statement and on the bus, and he was going to appear on Zoom today. He's been in sight since 8:30 trying to get on Zoom in about an hour.
He's on a bus?
Yes.
Where?
And on the bus, and he was going to appear on just now on this 8:30 trying to get on Zoom in about an hour. Sorry. But what she meant.
So I can't issue a bench warrant? He's in the building? Like where? Where? This is a big building. So I can't issue a bench warrant?
You're about to. And I will say.
You're doing that, people look toward the door hoping that he's gonna walk through it any moment.
I hope so, but I believe him. I will say this.
You do believe him?
Yes, Mr. Evans has never lied. And I will say.
You're doing that.
Never lied to me yet. This would be a weird first lie. I will say this.
You do believe
if I can so easily prove him.
I don't think he's in the building.
I will practice it. Never lied to me yet. This would be a weird first lie. Hurry.
Where?
If I can so easily prove him.
In the building. I'll pass it.
Thank you so much. I do appreciate it.
Right? Courthouse case, People versus Carlos Bank. Thank you. Courthouse case, People versus Carlos. Oh, okay. Oh. Ms. Rushing? Good morning. You want to state your appearance?
Yes, Judge, can you hear me?
Yes, I can hear you.
Okay.
Ms.
Looks
Rushing?
like I was having some connection issues. I apologize.
State your appearance?
Your Honor, Sydney Rushy, appearing on behalf of Mr. Mack this morning. Okay. And I'm saying name for the attorney of record, Mr. Burt. Mr. Mack, is that okay with you?
Yes, ma'am. State your Carlos Mack.
And can you state your name for the record? Okay. And I'm saying name for the attorney of record, Mr. Burt.
We got that. I have here that an alcohol screening assessment was completed and defendant is currently being held with no bond because of his sober length factor.
That is correct, Your Honor. It's my understanding that to complete his assessment, he cannot do the portion that he has to complete yet in the custody. I believe that there is a request and agreement to allow him to be released on a scram tether so that assessment can take place and that his sentencing can proceed forward at the next stage. I believe that there is a request and agreement to allow him to be
I will allow the defendant to be released from custody with the scram tether that must be fitted on the defendant prior to release. Ms. Claire, were you going to do the referral or just Ann?
I can do it, Your Honor, if you'd like, or
No, Ann already has. All right. And that will be prior to release. Defendant has been referred to bond Schwartz for an alcohol screening and assessment. And the sentence in this case will be adjourned to February 11th, 2026 at 9 a.m. Thank you.
Thank you so much, Judge. Happy New Year.
All right. Yes, and to you, my staff was just saying, what are we doing?
Thank you, Your Honor. At this time, my client is asking that a preliminary exam be set in this matter. Your Honor, we are asking for this to be set knowing that there is some outstanding evidence. My client has been in jail for 135 days. We've asked for the DNA evidence multiple times. We just can't get the evidence. Your Honor, I'd also like to address bond when appropriate.
Well, I'll know every time we come off this DNA, and I'm not going to ask when it's going to be because that won't be the fact that once an exam is going to have it, but the fact that they don't have DNA is not going to be the basis for an insurance. You understand that, sir?
You understand that, Mrs. Johnson? Thank you. Your Honor, when appropriate, I'd like to address bond.
Will the people have their witnesses available the 17th? Preliminary examination, March 17th, 2026, 9 a.m. before Judge Moore. Esteban.
Your Honor, my client has currently been in for, I'm sorry, I misspoke, the line above. He's been in for 99 days. My client is very, very confident that the DNA on this particular item is not going to be his. He is asking if he could be tethered to his home. He's willing to do a GPS tether or even a home confinement tether. He does have medical needs that are not being addressed in the jail at this time. I have emailed about that, but there's certain, as part is aware, there's things that they can do and cannot do. He has significant back pain and various other issues. Matter of fact, the day before this incident, he was at Trinity. Thank you, Your Honor. At Trinity before this. So we're just asking that he be released on tether, whichever type the court is inclined to allow. He still has his residency, and he's asking to be released. So we're just asking that he.
Respond to the people. Motion for bond reduction tonight. Bond will continue. March 17th before Judge Moore.
Thank you so much, Your Honor.
Court calls case People versus Jasmine Moore.
Thank you so much, Your Honor.
And Assistant Public Defendant Nicholas Butkovich on behalf of Mr. Naparilla, who is now approaching. Please state your name for the record.
Michael Naparilla. I have before me a plea form that indicates that he's going to be pleading guilty to count 2, I think, of use of fentanyl for 1-year offense. Upon his successful proof of that charge, count 1 would be dismissed. There's an agreement to go upfront jail.
That's correct, Your Honor.
Let's have him sworn.
Michael Naparilla.
Sir, it is his court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Understand that? Understanding that you still wish to plead guilty? And to that charge, how do you plead? Now, you understand by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Or had one signed on your behalf, is that correct? Any question regarding any of those rights? Look at paragraph 5, you'll see a copy on the podium. Those are the rights that are part of the trial. You understand by pleading guilty, you're giving up those rights as well as all the rights. You understand you're giving up your right to appeal of right. Are you on probation or parole?
I'm parole in Ohio.
Okay, at the time of this offense, were you on parole?
All right.
They're aware of it. Okay, I do have to advise you that
this could be considered a violation of your parole. And if it is considered a violation, they could sentence you to the remaining portion of your term or send you back to do the remaining portion of your term or any other sanction in Ohio which would be available to them. You understand that? All right. And understanding that you still wish to plead to this charge? Anybody promise you anything other than what they're saying here today to get you to plead? Anybody threaten you or force you? You're doing this voluntarily and of your own free will, and because you believe that you are indeed guilty of this offense. On May 25th, 2024, at the location of Gulfside Road, Pittsfield Township, Washtenaw County, State of Michigan, did you have fentanyl in your possession? Did you use it? Did you know what you were using was fentanyl? Sir, if I accept your plea, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined under Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendations. You understand that? Counsel, you aware of any other promises, threats, or other inducements which would lead to this?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14-day-1 probation. Sentencing in this matter will be March 25th, 2026, noon, before me.
Your Honor, may I address bond when appropriate?
You may.
Your Honor, at this time, I'll be requesting a personal contact bond. Mr. Nakamura does have gainful employment. He does have a support system for his partner as well as his family. He just took, this case was just down, now reduced to a misdemeanor with an agreement for no upfront jail time. He will be willing to go and test and comply with any of the court's orders. He would test clean, obviously, as he has any custody for a short amount, for this amount of time. He does have, again, gainful employment, a car, a support system. He'll be willing to
aren't they gonna, take him back to Ohio?
for a short amount.
My wife had talked to my parole agent. They're not worried about it just because since I went to jail in parole, they knew about this charge when I was released, so they're not basically worried about it.
And he did, and XRO does show that the parole hold from Ohio was lifted. His parole agent did lift his hold, so he has no holds currently.
I don't need a question, because I'm gonna deny the request. I won't even consider release until such time as he's interviewed by my commission.
Understood, Your Honor.
Then that should happen. Court calls case People versus Michael Roseberg, then that should happen.
Court shall cease to assist him.
Michael Eugene Roseberg. Yes, sir.
Thank you, Judge. I did speak to my client. I believe he is requesting this matter entered. I believe we're requesting this matter be set for preliminary examination. To my knowledge, all discovery is complete. And I believe Mr. Roseberg will have to address bond when you're done.
He brought the witnesses available at 17. Preliminary examination in person, March 17, 2026. 9 a.m. before Judge Warren. That's the pound.
Thank you, Judge. You did this with Ms. Scott from our office this morning. He did ask me to address the bond. He indicates that he is currently employed, fully employed as a night's auditor / desk clerk. He still has that job available to him right now. He'd like to make sure he keeps that job. He does have 4 children, 2 of which he supports the child support payments. He wants to make sure that he finds on those as well. Indicates he was last in trouble back in 2004 for a charge that has been resolved. He additionally indicates that he has his own place of residence right down the street here on Carpenter Road, and he would not have any contact with the victim should the court release him. He would have no problem with a tethered home with work release. He indicates he would appear for any and all court dates and follow any and all court orders. He'd expect the PR bond or a $5,000 bond. He believes he can afford to post that if the court does grant a bond. Your Honor.
At the time of this offense, for the police report, Mr. Roser had been bond out of the Bureau of Protected Victims. There were 3 different victims. This occurred when they were out with friends while driving home. One person driving and I believe 3 other women in his car. The defendant assaulted all of the victims. Punches occurred when they were out of the forehead and black eye scratches to her arms and forehead. He also has rules on Adrian for disorderly for $100 and Drew for $500 for assault. These convictions for breaking and entering, RNO, or driving assault on firearm and larceny for British those sending back 3,000 and beyond. But this permit
I don't have anything further, Judge.
Motion to wrong reduction is denied. Bond will be continued. Thank you.
Thank you, Judge.
Thank you. Thank you. Sharon?
Thank you, Judge.
Thank you.
Roy Gaines, Senior Assistant Public Defender, working on behalf of Mr. Sharon. Would you say your name, please, sir?
Thomas Sharon.
Okay, I have before me a plea form that indicates that he's going to plead guilty to an added count 2 of entry without permission, a 90-day offense. Upon the successful plea to that charge, count 1 will be dismissed. That is the court's full understanding of the agreement. Is that correct?
That is correct.
May I have him sworn?
Raise your right hand. You solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. State your name, please. State your name.
Thomas Sharon.
Raise your right hand.
All right, Mr. Sharon, it's this court's understanding you're going to plead guilty to the charge of entry without permission. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. You understand that, sir? Guilty to the charge.
Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. You still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
And you would be sentenced before Judge
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes, sir. Yes, sir.
You signed or had signed on your behalf and advised the rights for it? Any question regarding any of those rights? Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form. You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you the
You
plea?
understand you're giving up your right
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Sir.
And also because you believe that you're guilty of this offense? On the date of February 18, 2024, Wise Hall at EMU in the city of Ypsilanti, Washington County, state of Michigan. On the date of February 18, did you enter those premises?
Yes, sir.
Did you have permission to enter Wise Hall?
No, sir.
Did you enter those premises? But it wasn't. Was it open to the public? Did you have permission to enter Wise Hall?
Yes.
Or
I don't believe the hall open to the public. It may not have been properly closed.
My understanding from the video judge is that there's a security card.
It may not have been. So
Sure.
So you did not have proper access, but entered the building anyway.
Yeah.
And you knew you didn't have authority to enter the building.
Yes.
All right. So sir, if I accept your plea, if between the time that I accept your plea today and the time of sentencing, you commit misconduct as defined by the Michigan court rules, the court would have to advise you that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
All right. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
no, thank you, Your Honor.
You understand that?
Yes, sir.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be March 18, 2026, 10 a.m. before Judge Barr. Bond sentencing in this matter
Your Honor, will we address bond?
You may. March 18, 2026.
Your Honor, Mr. Sharon has indicated that, unlike at the time of the incident, which was, I believe, in 2024, he can stay with his sister who resides in Garden. That he will return for all court dates. He will either be able to walk or take public transportation or have support from family. We are asking that the court consider a PR bond, especially given the change in the charge.
Well, he didn't appear before, right?
Correct. That is correct.
Because he started out with a... So what you're saying, what changed from that?
He can reside with his sister. So he has a more stable situation.
Well, I would have to know where's the city.
Garden City. He has a more stable situation.
Well, I'm not going to change the bond. I will leave it at that. Certainly you can address that with Judge Barr as to that. But with his history before me at this point, I'm not going to change the bond. I'm not going to change the bond. I will leave it at that. Certainly you can address that with Judge Barr as to...
Pronounces it Reserve, is that correct? Reserve, all right.
Reserve, got it.
Yeah, Reserve.
All right. Getting time set for trial, and we're ready to proceed.
Before Your Honor, I did want to put on the record that there was a police officer that be discharged with sentencing under 7694 in its mind of sitting the defendant. It's rejecting the law.
So acknowledged she is, Your Honor, and we are ready to proceed as well. Thank you.
All right, very good. Opening statements, or are you waiting?
Sentencing under 7694 in its mind of sitting the defendant. It's rejecting the law.
So acknowledged she is, Your Honor, and we are ready to proceed as well.
I'll do short, Your Honor.
Pardon?
I'll keep it short.
All right, very good.
Your Honor, today we're here, it's been a trial. Today, the court will hear testimony from D'Angelina Terrell, who the court will hear was in a relationship with Mr. Savvy. They have 2 children in common. The court's going to hear from Ms. Terrell the events that occurred on Mr. Terrell, who the court will hear was in a relationship with Mr. Savvy, where she was pushed after trying to put their children to bed. And I believe at the end of this testimony, the court will see her testimony, see her demeanor, and find her spending where she was pushed after trying to put their children to bed.
Skinner, would you like to give an opening statement, reserve, or waive?
Give one, Your Honor. Quickly, Your Honor, this case, as you heard counsel say, goes all the way back to September of 2024. At that time, my client, Mr. Rezavi, was and is a veterinarian, a National Guard veteran. He was living in Pittsfield Township, sharing custody with the complainant, Ms. Terrell, of 2 children that he thought he was the father of, and later learned that she had lied to him, was not the father at all, which I think will reflect on her credibility, which is clearly going to be an issue in this case. But nonetheless, they shared custody at that time, 50-50. He had the kids, and he invited Ms. Terrell over. You're going to find that their relationship was toxic, probably at best, but they still did sometimes hang out, and that night they were planning on hanging out a little bit, so he went over. The kids would not go to bed, being rambunctious because mom and dad were together. It was getting late, so John told her, "You got to go." Over the course of about 45 minutes, he kept saying, "It's time for you to go," for lack of a better legal word, revoking her ability to be in his apartment. She told the police she protested. She didn't want to leave. She wanted to hang out with the kids, and that caused some friction. As for what allegedly happened, Your Honor, my client will tell you that as he's standing in the doorway saying, "I'm going to get your purse, it's time to go," she loses her cool, smashes by him, pushes him up against the wall where he smashes his head and shoulder against the wall, leaving a divot in the wall and redness on his head. She runs, grabs the phone, and calls police. Now, what she tells police, Your Honor, is that he pushes her and that he smashes his own head against the wall, which I think the physical evidence, my client's testimony, and he will testify in this case, will definitely belie that. I'm hopeful at the end of this case you'll find that this was toxic and this was immature, but this was not criminal, especially at Mr. Resevi's hands.
May I call your first witness?
Thank you. People call D'Angelo Terrell.
This was immature, but this was not criminal, especially at Mr. Resevi's age.
May I call your first witness?
I'm sure as part of the testimony about to give the truth, the whole truth, and nothing but the truth, so help me God.
Yes.
Yeah, see, state, spell your first and last name correct, please.
D'Angelo Rankin, Deangelennan, but my former last name is Terengen.
Go ahead, you may go.
Thank you, Your Honor. And you go by Lena.
Yes.
Lena, do you know a John Resevi?
I do.
How do you know him?
Go ahead, you may go.
Thank you, Your Honor.
Tender, when we were both living in Manhattan.
Lena, do you know a John Resevi? Did you have a relationship? How do you know him?
Yes, it was one of the friends with benefits.
Did you have a relationship? So you had a kid together? If you saw John today, would you recognize him? Is he in the courtroom right now? Can you identify something he's wearing and where he's sitting? So you had a kid together? If you saw John today, where's he sitting? Is he in the courtroom right now? Can you identify something he's wearing and where he's sitting? Okay. Your Honor, please let the record reflect that this witness has made an incorrect identification of the defendant.
Record shall so reflect.
So I'm going to direct your attention now to September 24th of 2024. On that date, were you at 3341 Primrose Lane? And is that in Pittsfield Township, County of Washtenaw, State of Michigan? And on that date at that location, did Mr. Resevi do anything to you that made you call the police?
Yes, so, he had asked me to leave after, 3 weeks to bed, and I was trying to do something, but I didn't grab the first as I was walking to grab the first. He had cut me off and started pushing me more towards the stairs. And, it was like, I mean, it happened. I just knew that I started hearing the kids cry. And I told John, I was like, hey, the kids are watching their phone. We kind of stopped
Okay, so let's just kind of start back at the beginning. Whose residence is that? Okay, and how did you end up being at that residence on that day?
On that day, I went to class and we were in the middle of a place, so
And how did you end up
independent worked on that. And he had asked me to pick up a target order that he had placed that was ready. And I told him to do that. And she came on the phone and asked us if the kids weren't going back to their legs because I didn't want to go inside. Because I knew that my presence would like rile him up. And I didn't stir them up right before bed. He told me they were sleeping. I had a clicker to his garage because it was kind of like a townhouse condo situation. So I opened the clicker and before I could even open the door, our eldest son, Alexander, opened the door. And I told John, because he was standing there, I was like, don't worry about it, I'll just do that for you. And then we had kind of talk later because the whole point of me being there was to talk. I forgot my part, but we were just going to talk for you.
So then, sorry to cut you off. So you got it there, kids are awake, you go in the house and you're going to put them to sleep.
Yes, I told him I would put well, at the time I thought it was just one son, but then I saw the other son was awake too. So I said, I'll go to sleep.
You're going to put them to sleep.
And we could talk with them. They were awake too. When Arthur was asleep, Alex had to go to sleep. And John had came in, and he was just like, they don't do this while you're eating. It doesn't go like this. They're only doing this because you're here. And I told him it was fine because Alex had just fell asleep and Arthur was on his way to sleep, like, you know, just gave me like 30 minutes. And Arthur should be asleep. And the second time he came to his room,
That's when he asked me to leave. But at that time, Armin was like 2 seconds away from actually like being into deep sleep, and I asked him if I could stay just a little bit, just so he could fall asleep, and then I'll leave. And he was like, no, you need to leave now. And I was like, okay, fine. So we went through the stairs, we said the room entrance. And so I was going that way. He was like, no, you need to leave to the bathroom. But the way that their door is set up is like, when the room entrance door is open, it blocks the bathroom doors and so I moved the door.
The hallway door?
The entrance to the room door to get into the bathroom, because the bathroom cuts out into like the little hallway that his house has. And so when I did that, he was like, bitch, did you just try to close the door on me? And I was like, no, I'm just trying to leave. And then he cut me off as I was trying to get to the kitchen to grab my purse and stuff. And that's when he started pushing. And I kind of started pushing him off of me and asking him to let go of me. And he wasn't trying to let go. He was like, no, you need to leave, you need to leave, you need to leave. And I was like, I'm just trying to leave. I was like, I'm just trying to grab my purse. And that, I don't know how long that went on. I would maybe say like 2 to 3 minutes of him trying to push me and me trying to like get him off me, because the way that his house is laid out, there's like a small, short set of stairs and then a very long set of stairs, and tile at the bottom of those long set of stairs. And in that moment, I was scared that he was trying to push me down the stairs. Because that's how badly he wanted me to leave. And like I said earlier, the only reason why he's like kind of let go of me is because I said, hey John, the kids are watching her cry. And they were. All the police. As I told John, I was calling the police. I suddenly decided to hit his head against the wall and said that I hit him. I was nowhere near him at that time. Like, as far away as I could be, trying to call the cops.
So how did this whole incident make you feel?
It made me feel scared because like John and I have gotten into fights before. But like I never felt like my life was in danger. I think I was able to come off like, wow, this man's really trying to hurt me. And I couldn't even tell you like what I did wrong to even make him want to like try to.
You may have one moment.
And I couldn't even tell you like what I did wrong to even make him want to like try to.
You may have one moment. And I know you mentioned your 2 sons. Are those 2 sons you share with Mr. Rysavvy?
Yes.
So he is their parent?
Yes.
Okay.
It's his biological son. That's something we found out later down the road. And that turned into.
Are those 2 sons you share with Mr. Rysavvy? So he is their parent?
We found out, well, John did a DNA test on Alexander a month or 2 after the incident happened, and found out that he wasn't his biological son. We found out, well, John did a DNA test on Alexander.
And that's the older one?
Yeah, that's Alexander. A month or 2 after the incident.
And the younger one?
Is Arthur. And found out that
And
he wasn't his biological
was the same testing done?
son.
That's the older one? And the younger one?
Right.
And
I have one more moment, Your
was
Honor.
the same testing done? That's the older one? And the younger one? And
I have one more moment, Your Honor.
same testing done?
Nothing further to this witness, Your Honor.
All right, cross-examination.
Thank you, Your Honor. Mr. Brennan, good morning. Listen, start with the location at Primrose Lane. That was Mr. Resevi's house, yes?
Yes.
You were not on the deed, you were not on the lease, you were not on any sort of documentation, correct? You had your own house or location, yes? So he, I think you told the judge and the prosecutor, he told you to leave several times, yes?
And then when I was trying to grab my purse, because it was in the kitchen area, that's when he was like, no, you need to leave, but I can't leave without my keys or my wallet.
If I heard you correctly earlier, I think when the prosecutor was asking questions, you said, and I quote, "Give me 30 minutes." Is that correct?
He asked for the kids because he didn't ask me to leave at that time when he came in the first time. He was just getting agitated, saying that they don't do this while I was here.
So if you're asking to give me 30 minutes, what are you asking him to do? What?
I said, give me 30 minutes so I could finish putting our youngest son, Arthur, to bed. Because the whole point of me being there was to talk and hang out.
Okay, so give me 30 minutes is in response to him telling you it's time to go.
Give me 30 minutes. What are you asking him to do?
You use the word with the police, who I think Officer Branch is here, over my shoulders, that you protested. I think that was your word on the video, correct? Okay, so give me 30 minutes.
I just said that I wanted to finish putting them to bed because I was there and I knew the moment I left, rile them back up.
Do you recall using the word protest to the officers? I protested for 30 minutes. And ma'am, with respect to a 911 call, what was your intention in calling 911?
I still had my purse at the time to leave, so that was the, so that I could be able to leave safely, because at that point, he just put his hands on me, he just tried to push me. I just wanted to leave.
So I'm curious then, why is the call and about him smashing his head in the wall repeatedly, why are you telling the dispatchers that?
Because he just did that as I was calling them. Like the moment I said I was calling 911, he started hitting his head against the wall. And that was very confusing to me. And so I let them know because I wasn't near them. In fact, the kids were the closest to me. And I informed them that the kids were, that there were kids present. And that what had happened was that he was trying to push me.
I mean, you guys had a custody arrangement at that time, correct?
Yes.
It was 50-50, correct?
Yes.
In response to the question I think the judge asked you, you had told Mr. Resevi that Alex was his child, yes?
Yes.
And he was paying support for him, yes? Continues to, yes? You had the children 50-50. This was his night on September 24th, 24, correct?
Yes.
Well, so that's a little tricky.
He was paying support for him.
Custody agreement actually states that on Tuesday, I pick up the kids.
This was his night.
But because I was going to school, but at that time I had asked him if we could. Custody agreement addition states that on Tuesday, I pick up the kids.
So whose night was it on this night?
It's technically.
Okay, and this particular night, you guys had 50-50 custody, correct? Did you seek to try to change after this?
Not full custody, but like
So whose night was it on this night?
But like after this incident, John's behavior has grown increasingly concerning. To the point that the kids were coming, telling me very concerning things.
Now, Ms. Brennan, when you first gave the story to the judge, you said that my client had sort of his hands up and was stopping you from coming back into the apartment. Is that accurate?
To the point that the kids were coming, he actually was pulling me and pulling me by my shirt and then pushing me by my shirt, if that makes sense.
Did you have any sort of stretched out shirt, any marks, any injuries, anything that you could show the police to what we call corroborate that? Did you have any injury whatsoever? to your knowledge, did you see injury to Mr. Rasevi's head?
Did you have any sort of stretched out shirt? Any
But
marks,
of course,
any
your
injuries,
testimony is that
anything
he
that
put
you
his
showed the
own
police
head
to
into the wall. Is that correct?
corroborate that?
Yes.
Okay, all right, no further questions.
Did you have any injury whatsoever?
Hey,
To your knowledge,
I
did you
guess
see
I'm
injury
trying to
Mr.
figure out.
Rasevi's head? Did you have any sort of stretched out shirt?
He asked you to
Of course,
leave,
your testimony is that he put his own
right?
head into the wall. Is that correct?
At some point.
Yeah, he asked me to leave, and
But,
then
but what was your response to him asking you to leave?
my response was, Carrie just finished playing an argument that he's almost asleep.
Is that the give me 30?
No, that's not the game.
Okay, so when does the give me 30 go?
That was prior. That was the first time he came. He didn't ask me to leave, but he was being agitated and saying that they don't do this while I'm here. And I just told him to be here to then stop that. Putting them to bed.
And so how much time had passed before that comment and then him asking you to leave?
I wasn't aware of the time.
So how much time?
See, but I feel like it wasn't 30 minutes. It was definitely less than that.
When you said give me 30, what was his asking you to leave?
He said, okay, and then he closed the door.
And then at some point came back?
Yes.
So when he asked you to leave at that moment, I guess my question is why didn't you leave?
Because Arthur was still awake. His eyes were closed, but he was still awake. And I knew if I were to have gotten up, that would have just like kind of reawakened him. And that's when I was like, what is this finish with him sleep? And I'll leave because I was like, he's the down. It's like, okay.
Okay, so that was 2 times that he's asked you to leave, because he said, he asked you to leave,
Yes.
you didn't right then, right? And then he said, no, you need to leave right now.
Yes, and then after he said that, I was like,
Okay, so that was 2 times.
but then what I think kind of escalated the situation when I was trying to leave out of the bedroom entry door. He told me not to do that. He told me to leave.
Where was your cell phone?
And then it was in my hand at the time. Because I had it in the room.
Okay. And then when you exited out, did you exit out the bedroom door or the door that leads to the hallway through the bathroom?
The door that leads to the hallway through the bathroom because he was standing in front of the bedroom.
Didn't ask why, but that's the door you exited out of. How far is the stairway from that door?
I would say that.
Okay. And then did you, didn't ask why, but that's the did you head down the stairway? How far is the stairway?
No, because I didn't have my purse in the room with me when I was putting the kids to bed. It was in the kitchen area on the low countertop.
And is that on the lower level?
No, that's on the top level.
That's on the same level as the bedrooms?
Yes.
Okay. And so you went, you said, let me get my purse. And then you went to get your purse?
But that's when he cut me off before I could even grab my purse. And he started like pushing me more towards the stairs. Where the door would lead to. Like there's a short set of stairs, like 2 or 3 steps. And then there's a long flight of stairs after that. That leads to like the doors.
Did you ever get your purse?
I did, once the police were there.
So prior to that, you didn't get your purse. So, did you leave the building?
I went downstairs.
Okay, so hold on a second. When you went downstairs, your purse is still upstairs?
Yes, because at the time I was on the phone with the police.
So you called the police from upstairs?
Yes, because after you let me go, I was able to call the police. Because I was trying to get his hands off of me so he couldn't push me down those stairs.
So you called the police from upstairs?
Yes. After you let me go, I was able to call.
They ask you, if you had your cell phone with you and he wasn't letting you get your purse, why didn't you just leave? And then, as you did, call the police from outside or wherever and ask them to come so you could retrieve your purse.
Because I didn't even get that opportunity. Like, once I went to the direction of my purse and he cut me off, that's when he started pushing. And that's when the whole altercation.
No, what I'm saying is, okay, that happened. So why didn't you then turn, go down the stairway, go outside, call the police to then get your purse?
He was holding on to me, like, he wasn't trying to let me go. I didn't have the opportunity to even to fully even push him off of me so that I could even go up the stairs. The only reason why he let go is because the children saw what he was doing. And after that, I went downstairs. Like, I called the police, I started getting downstairs, getting my stuff off, and the kids too.
So, Mr. Guerin had asked you about a custodial arrangement. And so, this was a school day?
It was. It was a Tuesday.
Okay. And so the 50-50 arrangement at the time was what?
It was,
this was school day?
So it was like Friday evening, Saturday, Sunday.
50-50 arrangement.
Saturday, Sunday, every other weekend. And then.
Stop that, stop.
Sorry.
When you say every other weekend.
Right. Friday evening, Saturday, Sunday.
For him?
Yes, for him. It's every other weekend. I have a
Stop that, stop.
He
When you say every other weekend. And then what happens during the weekday?
The weekday he has them on Monday and Tuesday. Yes,
And this happened on Tuesday.
yes.
So why do you say that was your day? And then what happens
Because
during
the way that our original agreement was laid out was that he has them until Tuesday morning, and then I pick them up in the Tuesday afternoon.
Well, that won't work, because really, the agreement would talk about overnights, right?
Yes.
So who had custody that Tuesday overnight? Because really, the agreement would talk about
I did. It was my night, but I had asked him to take care of the kids because I have class in 3. So I wouldn't take care of.
So suffice it to say, despite the agreement that when you requested that of him, he was to then take care of the kids.
Yes.
And they were going to stay that Tuesday overnight.
Yes.
Despite the agreement. And then again, why were you that of him? He was to then take care of the kids.
There?
Yeah.
And
they were going to stay that Tuesday overnight.
And he also had asked me to pick up his target order because he ordered PS5 controllers for the kids, and I said that's fine. That would do.
Yeah. And they were going to stay that Tuesday overnight. So you asked him to hang out. So all of this, what time were the kids being put to bed? So you asked him.
I didn't get to his place closer to like 8:30, 9 o'clock-ish. I don't remember the exact time, but I know it was
And had you picked up the target order?
Yes.
So it was 8:39. What time was during that time the kid's bedtime?
I don't know how guys are very structured at this house, but mine is 7 o'clock.
So it was 8:39. What time was during that time the kid's bedtime? Okay, were they in bed when you got to his house?
One of them wasn't. Alexander, the oldest one,
How old is he at the time?
he was about to be 6, he was 5.
Okay.
He was 5, and he was up. He had opened the garage door for me before I even opened it.
Okay, so.
About to be 6, he was 5.
Okay.
He was 5.
At some point, but I mean, they're dressed for bed.
Yes, they were dressed for bed. But I had informed John to let me know if they were up because I would have to inside. Because I knew that I was all up. He was assuring me that they were in bed. I had informed John to let me know if they were up. And so when they saw me, like, oh, Mom's here, Mom's here. I knew that I was all up. So that's when I was like,
Any questions based on the court's questions?
None from the people you're asking.
No, right, thank you.
Hey, step back. Any questions based on the court? Call their next one.
People no further witnesses.
All right. Witnesses for the defense.
Your Honor, at this time we would call John Residue, please.
Sir, please come forward. Any questions based on the court? Call their next one. All right.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth, so help you God.
I didn't.
So have a seat. State and spell your first and last name.
John Residue, J-O-H-N, R-Y.
Take a seat, raise your right hand.
Inquire.
Thank you, Your Honor. Mr. Residue, good morning. Ask you, do you remember the events that occurred, did or did not occur on September 24th, 2024 at 9:40 p.m.? I'm just going to ask you point blank that night, John. Did you aggressively push Ms. Terrell Brennan at any time that night? Did you aggressively grab her sweatshirt, tug her sweatshirt, pull her in any way? Did you, I know it's a legal term of art, do you believe you assaulted her in any way? Were you violent towards her? Did you intend to harm her? Did you threaten to throw her down the stairs? Did you smash your own head against the wall? We're going to talk about all that in some details. Let me ask you a couple questions about you, sir. How old are you? And at the time, I'm guessing, what, 32 or so, yes? What do you do for a living? How long have you done that? I mentioned you're also a military veteran as well. What branch? Are you still in that or no? At the time, I'm guessing, what, 32 or so. We heard some questions about Ms. Terrell Brennan and your relationship with her. You two were never married, correct? Military veteran as well. Just very quickly, did you believe you had 2 sons with Ms. Terrell Brennan? When did that change for you? About Ms. Terrell Brennan and your relationship with her. And we heard some talk about a DNA test. Did you take a DNA test? Just very quickly. Was that self-initiated? Did you believe you had? And did it, in your mind, prove that the oldest Alex was not your biological son? Had Ms. Terrell Brennan previously told you that he was? And did she fight that he wasn't your son at that time? Was that self-initiated? At the time of September of 2024, is it accurate to say the two of you had a 50-50 custody arrangement? Heard the judge ask us some questions. September 24th, do you recall if that was your night, Ms. Terrell Brennan's night, or you don't recall? Okay. But were the children at your Primrose address? I asked her that she had Ms. Terrell Brennan had a separate apartment or separate location, yes? I want you, from your own perspective, to tell the judge what brought you two together that night.
But were the children at the Primrose address?
And who initiated contact?
She had Miss Geraldine had a separate apartment.
And so, was the plan to meet up after the children were asleep?
What brought you two together?
And do you recall what time she arrived? Were the boys sleeping at that point?
Initiated contact.
They were in their rooms. And so, what happens after Miss Brennan arrives?
Children were asleep. And do you recall what time she arrived?
Doing that, Arthur illness.
Were the boys sleeping at that point? Initiated contact. They were in their rooms. And so what happens after Miss Brennan arrives?
Okay. And I guess I'd ask you from there, did the night start to change a little bit?
After illness, we
And so what happens
And you said waited for what?
Did the night start to change a little bit?
Okay. At any point, Mr. Rezavi, did you ask Miss Brennan to leave? How many times would you say you asked her to leave?
And you said waited for what? Did the night start to change a little bit?
Probably at least 10 times.
At any point,
Getting back into your mindset, why were you asking her, telling her to leave?
how many times would you say you asked her to leave?
One of the kids dead because it's going to be able to
And you said asked her many times. Did she agree?
Getting back into your mindset, why were you asking her, telling her to leave?
She's thrown out the bathroom door. Was starting to go downstairs, turn around. She just,
You said
I told her, I'll grab it.
Getting back into your mindset.
She continued and tried to force her way through me. Help me around. Turn around. And then during that, I had my hands up and locked myself. My hands pushed out. I snagged my thumb on her hoodie. At which point she began to hit and shove and I started retreating on back.
All right, lots to unpack there. We heard some conversation from her earlier that she said, give me some time, give me 30 minutes. Do you recall that statement? You said a second ago to the judge that you said, I'll get your stuff. What stuff were you going to get for her?
We heard some conversation.
She also had walked off.
She said,
I didn't realize she had got
some
this.
time, give me 30 minutes.
She received that. So first I gave to her.
You said
When she finally
judge that
decided to go down the steps,
get your stuff. What stuff are you going to get for her?
grabbed it and tossed it in a little square where the stairs changed direction. For her to grab, didn't realize she had water bottle. Police told me that it was still there, so I gave that to them and then I returned.
All right, if we can back that up a little bit. At what point did you give her the purse back?
After she was shoving me, I hit my head. She called the cops and then she left. But once you grab it, I gave that to them.
Okay. Going back in time, when you say you'll get her stuff, why did you not want her coming back into the guts of the apartment? Did you say a ring?
Going back in time.
And so when you tell her you'll get it, does she allow you to go get it for her at that point?
Guts of the apartment.
Okay. I want to ask you about the physical contact in very specific detail. I know I asked you this from the start, but did you sort of stop her physically by putting your hands on her?
She allow you to go get it?
She was the one that was.
You indicated a second ago that your head hit the drywall. Can you tell the judge exactly where that occurred, how that occurred?
Physically by putting your hands on her?
I can start at near the edge of the stairs. After she starts shoving me.
Sir, the layout of this location, is everything upstairs?
Gotcha. Okay.
And was the person in the kitchen area or where do you think, where was her personal kitchen? So it wasn't in the kitchen area.
And was the person in the kitchen area or where do you think, where was her personal So it wasn't in the kitchen area.
Did you tell her to leave through the bathroom?
I didn't tell her specifically the bathroom.
You didn't. What did you tell her?
Together,
Did you tell her to leave through the bathroom?
I didn't tell her specifically the bathroom.
You didn't. What did you tell her? Between the two of you, physical contact between the two of you took place in the hallway area. Is that correct? What did you tell her? Between the two of you, physical contact between the two of you took place in the hallway area. Is that correct? Were you not supposed to have the children that day? Do you recall?
I do.
You don't recall? After this, was there then any other like family court actions or anything that occurred between the two of you?
In March, we had the court hearing, and then it's March of 2025, September of 2025.
Okay, leading up to the March hearing, how was that initiated? What happened?
She initiated it after 2005. So between my life and mine, I would say it's the kind words about her.
How was that initiated? Okay, so this incident happened at the end of September. Sometime in November, there's the DNA test. All right. After the DNA test, then within 3 to 4 months after that, you guys are back in court. Sometime in November. That hearing, from your perspective, what was the purpose of that hearing? After the DNA test, then within 3 to 4 months after that, you guys are back in court. That hearing, both or for what? What was the purpose of that hearing? Adjust it from 50-50?
Yes, from 50-50 to current arrangement, which is every other weekend. She has them.
Say again?
I have them every other weekend. She has them.
Adjusted from 50-50? So she wanted it adjusted from 50-50 to basically a 65-30. So she wanted it adjusted from 50-50 to basically a 65-30. During the course of those, you actually had a full hearing before a referee? Did you have a hearing before the judge then? Course of those, you actually had a full hearing before a referee? Did you have a hearing? Did this case or this incident become a subject matter of that hearing at all? Pardon? He was not brought up. Pardon?
Arrested
for blood pressure. Become a subject matter of that hearing at all? He was not brought up. Pardon? So prior, it's going to sound like a strange question. Prior to this time, to this September 24th day, were there calls like this before for you guys to get together to have sex, or there were? Would that occur always at your house or at her place, or how would that work? Pardon? Primarily at your place. And who would initiate those calls? Both do. Okay. And on this occasion, she initiated.
Your Honor, I spoke to Mr. Alexander, and we've come to an agreement. The amount of rent that's owed is $2,310. Court costs of $175 for a total of $2,485. Mr. Alexander says he can pay that by next Wednesday, which will be the 4th. So obviously, I'm going to give him till the 9th. We both signed the judgment, and I advise the direction of the court ruling.
Sir, is all of that correct? Do you have any questions regarding anything? No. And you did receive your right of rescission. Court will enter that judgment by consent. All right, if you need a copy, you can get a copy. All right, have a good weekend. And you did receive your right of rescission. 103 South Hira versus Joshua Berkman. Court will enter that judgment by consent. All right, if you need a copy.
Good afternoon, Your Honor. David Fancher.
Your name?
Joshua Berkman.
Thank you.
We come to an agreement on this one also. The amount of rent is $245, court cost of $175 for a total of $420. Mr. Bertram says he can pay that by Monday. I gave him obviously till the 9th, and I was thinking that because the amount is relatively low, we should put under further orders, no writ without a hearing. Have I caught on now?
Yes, you
finally. So what that means is that if for some reason you don't pay, and if I file an order of eviction, the court would set that for a hearing.